Can we have the amicus, whoever the amicus are present today? So shall we proceed with hearing the views of the amicus first? Who are the amicus in this case? Present today. Huh?
Sir, Arif.
अच्छा आप क्रिमिनल मैटर पे है ना स्टेज 2 मंजूर मलिक साहब पे शायद नहीं है तो पहले हमने लेट्स हियर द कॉन्स्टिट्यूशनल पॉइंट्स दैट वी हैव नोटेड देन विल कम टू यू इफ यू हैव द टाइम सो आप हैं और कौन थे सलाउद्दीन साहब थे और यही दो थे नहीं और
Mr. Khalid Javed Khan was there, but Mr. Khalid Javed Khan is unwell. He'll be here on the next date. He's down with flu.
Did you discuss it with him?
My lord, he told me that he will be here.
No, are you of the same view or you didn't have any discussion?
No, my lord, we did not have a discussion. I called him yesterday, but he was quite unwell.
Mr. Salahuddin, do you mind? He's senior, he can... Okay.
Zahid Ibrahim, ये है सारा।
ठीक है ना Zahid Ibrahim, you are for a party. Yes, okay, fine. No, he was a party. Here or no? Okay. Ji, please.
Last time I think, sir, Ms. Umar had sent her submissions in writing. I haven't seen them. But
I think Mr. Yasir Qureshi
have you filed anything?
My lord, we had filed some bulletins last time. I had also placed a note before your lordship last time when I was on my feet when this honorable court rose.
Okay. Do you mind referring to it?
Professor Qureshi ka bhi
Because so much has been happening since then.
Yes,
that
my lord. Your lordships have been very busy.
Don't assume we have read it. You have filed these 2 volumes. In addition to the 2 volumes or just the 2 volumes?
My lord, I'll be submitting another one today, but those 2 volumes are there. I had, when your lordship was rising...
These are the 2 volumes. These are case law or whatever? Okay. Please proceed.
Yes. In the last 2 volumes, may I just identify what had happened? If your lordship takes a look at volume 1, your lordship will see. I'll just take your lordship through the index. I realize how busy you are, and there are a number of counsel your lordships want to hear. I had put in a comparative chart on the advisory jurisdiction. If your lordship just glances through the index of volume 1, then I had put in some judgments, Pakistani, Indian.
Volume 1A likha.
Volume 1. Volume 1.
There's 1A, it says.
There's 1A as well, but then there is volume 1.
Okay, the blue one.
The blue one. The blue one, right? Yes.
You want us to see the chart?
My lord, your lordship had seen it last time, but I may just show it to your lordship again. If your lordship would do is, may see, what I have done is that produce the respective provisions of the various constitutions in a table as compared to another, so that your lordship
leading to what conclusion?
My lord, that when your lordship is looking at a judgment cited from a foreign jurisdiction, your lordship will see to the extent the language is similar or not, and also when your lordship takes a look at the advisory jurisdiction provisions as they have evolved under the 1935 Act of India and then under the previous constitutions of Pakistan, what was the language, then when your lordship is examining your own judgment, your lordship will know that whether there's a difference or not. Your lordship will see one of the significant differences, that now the word may has been changed by shall in Article 186 of the Constitution.
Which word?
My lord, if your lordship takes a look at Article 186 of the Constitution, it is desirable to obtain the opinion of the Supreme Court on any question of law. If your lordship moves to paragraph 2, the Supreme Court shall consider a question so referred to it, shall consider a question so referred, and reports its opinion.
Original constitution had may.
No, the Pakistani constitution 73 always had may. Earlier constitutions in Pakistan had may. So the submission based on that was that where Otherwise, there may have been a discretion for this Honorable Court to answer or not to answer a question. Now this Honorable Court will have to look at the question and answer it. Of course, there is the jurisprudence of your Lordship, that where your Lordships have said that if the question is too vague, we will not answer it, or we will reformulate it and answer it. My Lord, there are certain judgments which are then followed, which were then handed over last time.
What's according to you the question of law before us?
My Lord, the question of law, according to me, the one on which I would be making my submissions is the one which is framed in the order of this Honorable Court of 21st of April 2011. And it was there also in the presidential reference. If your Lordship takes a look at volume 6 of the paper books which are before your Lordship, this is there as question number 1, and it is also as question number 1 in your Lordship's order of 21st of April 2011. Whether the decision of the Lahore High Court as well as the Supreme Court of Pakistan in the murder trial against Shaheed Zulfikar Ali Bhutto meets the requirements of fundamental rights as guaranteed under Article 4, sub-articles 1 and 2A, Article 8, 9, Article 10A, due process, Article 14, Article 25 of the Constitution of the Republic of Pakistan. If it does not, its effect and consequences. That is really the pivotal question.
Whether it was considering the main judgment of the Supreme Court or in the review, it was considered or not?
What, my Lord?
This question.
No, my Lord, the submission is that it was not, and what your Lordship will be looking at, your Lordship can look at this entire matter, at this presidential reference, from one of two perspectives. One is the criminal law perspective, whether the evidence of an approver ought to be given weight or not.
We want you to focus on the constitutional aspect.
That is my submission.
I think the latter is the easy part. The earlier is the more difficult one.
Thank you, my Lord. I find the latter more difficult. So,
because you are basically a constitutional lawyer, maybe.
So I'm very pleased to and grateful to your Lordship for that out. So I'll focus myself on the second. My Lord, the question before your Lordship really is that whether that decision meets the requirements of Article 4 of the Constitution.
No, but before that, if you can just focus on the other primary question, is the remedy of appeal as well as review was availed of.
Yes, my Lord.
Now, how much room do we have, if any, under Article 186 in sitting in an advisory jurisdiction rendering an opinion?
Right, my Lord.
First of all, can we do so? And if so, to what extent?
My Lord, may I just respond to the last limb of your Lordship's observation first? In two cases within the jurisdiction of Pakistan, I know your Lordship have looked at your earlier judgments and rendered an advisory opinion. One of them is the latest case in the Rekotik case, where this Honorable Court...
Is it reported yet?
My Lord, I have had the advantage of reading the reasons of my Lord Mr. Justice Yahya Afridi and of my Lord Mr. Justice Mandukhel. The short order is there. The reasons of the other three learned judges, at least I have not had the opportunity of reading them, and I think the reasons of two may not be possible anymore, because only one of the three members is at the moment a judge of this Honorable Court.
I think it was said that there's no need to give any opinion. There's an order.
Yes, my Lord. And prior to that, my Lord, there is the Governor General's reference. And that reference arose in the particular context of this Honorable Court in the Tamizuddin Khan case, having taken a particular view on whether a statute was constitutional or not, and therefore whether the Governor General could act in a particular manner or not, followed by the judgment in Yusuf Patel's case, where this Honorable Court struck down a number of orders passed by the Governor General.
Can you give the references, please?
My lord, I'll give you a lot.
And they're 186 or they're 185?
My lord, in the Yusuf Patel case, it was at that time an appeal, and the appeal arose, that is PLD 1955, Federal Court 387.
PLD 1955 Federal.
55 Federal Court 387.
No, but if it's an appeal, we have no problem.
Yeah, my lord, no. What happened was that as a result of the decision in Yusuf Patel's case, because a number of statutes which had received the approval was struck down, the issue arose whether the government could function or not and how the government should function. And therefore, the Constituent Assembly having been dissolved, what was the way out? And therefore, a number of questions were raised in the Governor General's reference in PLD 1955, Federal Court 435. And this Honorable Court then provided an answer and suggested how it is to be dealt with. My lord, the questions of law which were originally referred to, your lordship will find them at 449, if I've got the page right. Yes, your lordship will see them at page 449. Your lordship will see what are the powers and responsibilities of the Governor General in respect of the government of the country before the new Constituent Assembly. The Federal Court having held in Yusuf Patel's case that the laws listed in the schedule to the Emergency Powers Ordinance could not be validated under Section 42 of the Government of India Act, nor retrospective effect given to them, and no legislature competent to validate such laws being in existence. Is there any provision in the Constitution or any rule of law applicable to the situation by which the Governor General can, by order or otherwise, declare that all orders made, decisions taken, and other acts done under those laws shall be valid and enforceable, and those laws which cannot without danger to the state be removed from the existing legal system shall be treated as part of the law of the land until the question of their validity is determined by the new Constituent Convention? So a direct question which arose from this judgment of this Honorable Court in Yusuf Patel's case was sent to the court and it was answered. This is just...
The question was sent here? Where does it say?
My lord, this is the... If you
originally referred were.
Yes, my lord.
And then what happened later? They said...
This is the judgment, my lord, where that question is then answered and the Supreme Court then...
Where is the question?
The question is, my lord,
questions originally referred were
page
suggested at
449, if your lordship may see.
These are the two.
Question number 2. If your lordship will see just before the indentation.
Yes, so there were 4 questions.
Originally referred were 1 and 2, subsequently 3 and 4 were also suggested, but your lordship will find a direct reference to an earlier judgment of the court in question number 2.
Did they say they can do so? Where?
Yes, my lord. That is the entire thrust of this long opinion, and they say they can do that.
Under 186, whatever. What was the equivalent of 186 there?
Yes. And the question is answered, and the same has happened.
So, can we see the equivalent provision? Now,
yes,
can we go to your chart?
Yes,
Should we go to your
yes.
chart?
My lord, the equivalent provision is there in the chart as Article 213 of the Government of India Act 1935.
Is it parameteria the same?
My lord, in a way it is not exactly the same language. If at any time it appears to the Governor General that a question, this is the last column,
Yes.
that a question of law has arisen or is likely to arise which is of such a nature and of such public importance that it is expedient to obtain the opinion of the Federal Court upon it, he may in his discretion refer the question to that court for consideration, and the court may, after such hearing as they think fit, report to the Governor General thereon.
Makhdoom, is the question that was Yusuf Patel correctly decided or collaterally addressing Yusuf Patel.
My lord, if Yusuf Patel was correctly decided, then the government of the day was...
No, but the question is not whether Yusuf
It's not.
Patel is correctly
No,
decided.
no. And the question over there, my lord, is that in view of Yusuf Patel's judgment, if it is strictly followed, what is to be done? And the court then provides a way out.
Which does not upset Yusuf Patel.
My lord, Yusuf Patel remains as the law, but if your lordship sees the reasoning, in spite of the fact that all those laws which have been struck down by Yusuf Patel are allowed to remain in operation, which were essential till such time that a new constituent assembly comes in and provides a legal framework for the country.
देखिए ना इस पे तो ये हुआ कि वो कहा कि यूसुफ पटेल the interpretation is correct.
Yes.
After that, how the government can run?
My lord?
How
Yes.
the government will run?
My lord, the
उसको तो benchmark बनाया ना कि that is the interpretation by the final interpretation by the court.
correct.
After that, so that is an opinion sought by.
The court that in view of the decision in Yusuf Patel's...
What was the decision that explained, Karlin? Because Yusuf Patel is not under question.
No, Yusuf, neither
That
is...
is one big distinction is
Ji.
this.
The consequences of Yusuf Patel were.
Because, my lord, if Yusuf
Way out
Patel...
was sought from.
If Yusuf Patel was good law, if Yusuf Patel was fully given effect to by all the executive authorities of the country as they are required to, then the problem would be that the government of the day could not function. And therefore, they were virtually indirectly seeking from the Supreme Court a way out to continue to function in spite of Yusuf Patel.
And in Yusuf Patel, there was a review filed or not? Or what was the...
My lord, I am not aware, but it shows that whatever was the
So was
situation...
Yusuf Patel's case passed in review or was it just
No,
appeal? Or
Yusuf Patel was it's a criminal appeal and that's the final decision. And if there was a review, it's not on the record, at least as reported in PLD.
Interesting thing, same 5-member bench.
Yes. Yes.
So it wasn't even a larger bench, it was the same bench. Actually, we are a larger bench.
Yes.
So-
And my lord, before your lordship, to my mind, the shorter question, the question of constitutional law is that if later or subsequent events disclose to your lordship that the judgment may have been infected or there was a reasonable apprehension of bias or reasonable suspicion of bias, can that judgment continue to be declared as good law?
So the question actually really could be, I don't know if that's possible, the question of law could not be going into the merits of the case, but the process through which that decision was arrived at. So at best, the question of law could be that this decision that took place, whether the process was correct or not. Yahi ho sakta hai na?
My lord, that is my respectful submission. My submission is that when your lordship approaches a judgment in your review jurisdiction, the question is whether it is in substance correct. When your lordship is hearing a jurisdiction of advisory opinion under Article 186 of the Constitution, as your lordship presently is, your lordship is not concerned with the substance of the judgment. The question is whether the process by which it was achieved is something...
Which could also be a ground in review. Bias could be a ground in review.
But my lord, if it was not apparent at
was
that
not
time,
known, yeah.
if it was
That
not
is not
apparent,
known.
it was not known. And my lord, your lordship will see in this century, the closest example would that be of Pinochet number 2. Because there, and your lordship will find, I'll take your lordship through those passages, when a differently constituted committee of the House of Lords, as it then was, looked at it, they were pains to point out, each member of the House of Lords repeatedly, one thing is clear, Lord Hoffman was not biased. They repeatedly say he was not biased. But
Pinochet comes up through a review, is it, or through a...
no, my lord, the UK House of Lords and UK Supreme Court, unless there has been a recent change, does not have a review jurisdiction.
So how did the matter...
A submission was made, submission was not contested, submission was approved by the House of Lords that if a judgment suffers from a real likelihood or reasonable apprehension of bias, the House will always have the jurisdiction to reopen it and re-examine.
So this was decided earlier as an appeal, it was decided and reopened later?
My lord, what happened was that the very, very brief facts of the case are that extradition of Mr. Pinochet was being sought. The secretary granted the warrant. The divisional court at that time was decided the matter. The appeal came to the House of Lords. I'm just very briefly recapitulating the facts. In the appeal before the House of Lords, Amnesty International made an application.
This is the regular appeal.
And his lordship's wife was a member of Amnesty.
Yes, two
that
facts.
was the thing.
But this question was raised during the appeal.
No, my lord, no.
That's what I'm asking.
Before the appeal, when leave was granted, Lord Hoffman was not a member of the bench. Then an Amnesty International application is moved. Again, Lord Hoffman is not a member of the bench to be joined as an intervener. When the appeal is heard, Lord Hoffman is a member of the bench. The bench, interestingly, my lord, splits 3-2, like it split in this case 4-3, 1 vote difference. 3-2 the bench splits, and the bench holds that the extradition should be granted, decides against Mr. Pinochet.
Hoffman is the majority.
Hoffman is the majority. What happens thereafter is interesting, which my lord, the Chief Justice pointed out. The parties make an application. Pinochet, on behalf it is made, that Lord Hoffman's wife worked for Amnesty International.
When was the application moved?
My lord,
This was after the decision had been given.
Oh yes, my lord. After the decision,
How late?
my lord, after the decision is given, then the issue goes back to the Home Secretary to issue a warrant of his extradition. Before the Home Secretary, a letter is placed on the record. The letter states, and initially the letters were anonymous, given the fact that members of the House of Lords were involved, said that Lord Hoffman's wife worked with Amnesty International. In response to which the information provided was that yes, she did, but she was employed only in an administrative capacity, not involved with the decision making of and that she performed certain secretarial duties.
And they took up this application.
This application is moved to the House of Lords. While it is still pending consideration, a further letter emerges. This letter now provides, it emerges from Chile, and it provides this is not enough. Lord Hoffman himself is a director and also chairman of another charity called Amnesty International Charities Limited. That is a charity which is controlled by Amnesty International. It has no role in the filing of the intervener application.
Thank you.
It was not involved in that participatory process, but Lord Hoffman was there. And he is, of course, as a member of the superior judiciary, he could not act if it was any remunerative capacity. He was employed in non-remunerative capacity. So financial interest going back to times was...
Khatam ho gaya.
Ji.
Then was the bench reconstituted?
Yeah, how was the application taken up?
The application was taken up by a completely reconstituted bench.
Under what jurisdiction under the UK law?
My lord, at that time, the Lord Chancellor constituted the bench. The submissions record that the counsel for Pinochet submitted that you have always the jurisdiction to look at a judgment if it is infected with bias. And this
only that portion can you read?
That, yeah.
Yes.
Only this very portion.
Yes.
Which volume 1?
My lord, no, this is a new volume. I just placed before your lordship. This is tab 12 of this volume.
And this jurisdiction is under what's the law that regulating the appeals and all?
My lord, appeal is over.
No, but what is the law? I mean, they file their appeals under what law?
Common law principle.
Common law.
Common law principle. This application is moved.
Where is this portion
My
attended
lord,
to?
if your lordship may turn to tab 12.
Page?
My lord, tab 12, it opens at page 119. This is 2001 appeal cases, 119. Your lordship may see first the petition itself is mentioned at page 121.
No, we just want to see the reasoning.
My lord, if your lordship turns to, and then just point, okay, I will just move away from the application and take your lordship.
Sorry to nudge you along, but we
Not at all,
we
my
are
lord.
constrained for time also.
Your lordship will see page 125. That is the first judgment, opinion authored by Lord Brown Wilkinson. There is introduction. If your lordship will see 126G, is it highlighted? The relevant portion is highlighted for your lordships.
Page
126G.
Before your lordship will see
Anyway, I
sideline.
just want to come to the reasoning part.
My lord, this shows that they were made an intervener.
Yeah, that's okay.
Then your lordship will see 127, the decision and afterwards. And the link is then pointed out, 127, if your lordship may.
No, I just want
to
to
the
see
opening
the
up.
mechanism, how they overcame their earlier decision. That's what I was wanted to focus
And
on.
also perhaps how did they go about opening the matter?
My lord,
I think their judgment is based on apparent bias. If you will see that page 132.
yes, my lord. Yes, my lord. But if
This
your
is the
lordship
only
may.
reason which I have seen that only the question of bias was raised there.
Yes. And that is the issue raised over here.
No, fair enough. The question is how did they open it?
My lord,
They say,
if your lordship will see the decision and afterwards on page 127. And your lordship was asking for timelines. The timelines are also here. Judgment in your lordship's house, the heading is decision and afterwards, was given on 25th November. The appeal was allowed by a majority of 3-2 and your lordship's house.
No, we've understood that.
My lord.
Now attend to the application and setting aside of the order of 3-2.
My lord. For that.
How did they open the door and how did they?
yeah, the opening of the door first, please. I mean, how did they open the door?
All right, my lord. If your
Or
lordship.
they did not even mention it.
No, that of course mention it. They point out that this is.
Why don't you come to page 132?
My lord.
It's the conclusion which talks about the jurisdiction. I think that's dealt with the issue which is.
Apparent bias is there.
And please read the jurisdiction part.
My lord, I will.
Page 132.
If your lordship may, before that, just graciously see the reasoning of the court begins at page 125. Your lordship was asking where is the reasoning of the court. 15 January 99, Lord Brown Wilkinson.
No, it says,
that's the first.
as my lord has pointed
if
out.
your lordship turns to jurisdiction,
Yes.
that is page 132.
Let's read it.
As I have said, the respondents to the petition do not dispute that your lordships have jurisdiction in appropriate cases to rescind or vary an earlier order of this House. In my judgment, that concession was rightly made both in principle and on authority.
Where is the authority?
My lord,
Where is
that-
the discussion
that
on
follows.
this?
In principle, it must be that your lordships, as the ultimate court of appeal, have power to correct any injustice caused by an earlier order of this House.
So the principle of injustice.
Injustice.
No, so where in common law is this principle?
My lord, as follows, there is no relevant statutory limitation of the jurisdiction of the House in this regard, and therefore its inherent jurisdiction remains unfettered. In Broome Castle, your lordships varied an order for costs already made to the House in circumstances where the parties had not had a fair opportunity to address argument on the point.
Not the common law.
Common law.
It's lovely.
That's the magic of the common law, my lord. It develops with time, with judges, as your lordship's approach evolves. Your lordship will see this.
Mazmoon Khan, one thing when you're addressing, I want to be very clear on this concept as well, because we have a review jurisdiction.
My lord, yes.
Our law is fairly settled about no second reviews. So where will we draw these lines if we are exercising such a jurisdiction?
I mean, enter
You
the
have to
Constitution
you
to
have
the...
to bear that in mind at each juncture.
My lord, there.
No, I'm just saying bear it in mind
Yes,
as you're making
Yes,
your
ma'am.
submissions.
May I just preface it right over here, my lord, that generally your lordships have always regarded that in two respects, a decision is always available for reconsideration. One is the case of fraud, but that is now taken care of
12(2), yeah.
12(2) by the statute.
Yes.
But the second is the case of bias. If a party is condemned unheard, or if the judge appears to suffer from a reasonable suspicion of bias, the test is as low as that, a reasonable suspicion of bias, then that can be undone. And if your lordship will see immediately after what my lord...
इसमें ये जो last paragraph है, conclusion जो draw हुआ है jurisdiction का, that is page 132.
जी.
इसको भी जरा देख लीजिएगा ना, because they have clarified.
Sorry, you were reading, I think. Let's finish reading
Yes,
this
ma'am.
paragraph.
Brown versus Castle, your lordship's varied an order for costs already made by the House in circumstances where the parties had not had a fair opportunity to address argument on the point. However, it should be made clear that the House will not reopen any appeal save in circumstances where through no fault of a party, he or she has been subjected to an unfair procedure. Where an order has been made by the House in a particular case, there can be no question of that decision being varied or rescinded by a later order made in the same case just because it is thought that the first order is wrong. So as your lordships noted earlier, there is no review
Paragraph which I was asking to you read.
Yes, yes, my lord.
This is
yes.
the same
Yes.
paragraph.
So
But
the
if you-
three crucial words that emerge from this paragraph are injustice, fair opportunity, unfair procedure.
Procedure. And-
Am I correct? Or?
Absolutely, my lord. And if your lordship will see, it flows into the next paragraph, apparent bias. As I have said, Senator Pinochet does not allege that Lord Hoffman was in fact biased. The contention is that there was a reasonable danger or reasonable apprehension.
Well, I think that's immaterial, probably where they were just being nice. I don't know. Let's leave that aside. I'm more interested in the constitutional legal principle, whether he was biased or not biased.
My lord,
I mean, we can say the same thing here also. I mean,
Yes.
you can't look into the hearts of men.
my lord, one of the reasons
Yes.
why the superior courts all over the common law world have evolved the test, which has varied from real danger of bias to real likelihood of bias to reasonable suspicion of bias, is that it is almost impossible to prove bias.
But here, is it a question of bias, or is it a question of admission?
My lord,
Bias is that I had something against the accused appellant. That would be biased. Admission is that knowingly I decided something wrongly and I admit to it. That, would it be bias or would it be an admission?
My lord-
Is it a different genre?
the latter part would be an admission of bias, but when your
No,
lord
it's not bias. It is admission of wrongdoing. It is.
wrongdoing, and when
I mean,
your
where is the bias? I have no bias, but on your saying I did something which I shouldn't have done in law. So I'm not biased against the person, but you prevailed upon me to do something.
But initially, from the portions of the transcript which were available and from what was appeared on YouTube, it appeared to be that the judge was saying that in this particular case,
Pressure tha.
is pressure tha. But when you
Where
read,
is the bias? He didn't say I hated him or I didn't like him.
but where he says that
Unfair procedure.
if your lordship reads his book, along with his two interviews, your lordship will see that he is very clearly saying that in the case of the High Court at least, the Chief Justice who
नहीं, वो अलग बात है. हम Supreme Court की बात कर रहे हैं ना. हाँ.
Supreme Court mein he says that at that time the judges were under certain pressure. He doesn't say that there was any particular pressure on him. He also mentions that the Chief
But this is, I think, a slightly different category of case from bias.
Unfair procedure.
So, my lord-
उसमें आएगा ना भाई.
My lord, the
If देखें या तो I don't take pressure, or if it is pressure that I cannot resist, then I should disassociate myself from the bench.
correct.
I don't know.
My lord, it will fall in the category again of Pinochet. Previously the test was financial interest or interested in the outcome of the
No,
case.
but then we will come under injustice or unfair procedure, not bias.
My lord, reasonable, if on reading the transcripts of those interviews.
But I think bias is something subjective. Unfair procedure can be categorized as something more objective. I think unfair procedure or acting under pressure of someone is on a higher pedestal as opposed to bias, because bias, you may think I am biased, but another person may not think I'm biased.
Correct.
And only I know if I'm biased or not. If I do something which is objectively, I say, I decided this case, Mr. Makhloom Ali Khan, though there was no merit in his case, I decided in his favor. Okay, that is something I am doing wrong. So there is no question of bias for anybody else, but I'm either favoring you or not, or just, I don't like you, I'm doing something, one of the two. So I would really put it in a different category and on a higher category.
My lord, it would, but then eventually they would all fall under the broader category which goes back.
No, but is this maybe because there's never been such a category? Maybe we need to create such a category, I don't know.
My lord, the category is created in Pinochet from the point that where they take the view that if he had...
There the simple question was, because his wife, because of self, being a member, he may have been persuaded to canvass or articulate the viewpoint of Amnesty International. That may or may not be true. We don't know. Only Justice Hoffman and his wife would know that. Or the subconscious may have prevailed upon it. Let's even go that far. But nobody is saying that intentionally knowing that this order he should not have passed, he did pass. If tomorrow Justice Hoffman came out and said, I was under a lot of pressure from my wife, that whatever, if you don't decide this way, please find yourself another place to put your head down at night. I don't know. Now that would be a different category of cases. But that would be an admission of wrongdoing then.
That would be a category of admitted bias by a judge who was presiding over the trial. Because, my lord, when a judge decides on the basis of any other factor except the evidence before him and the law applicable to the case, it is said, there are categories, it is said that the judge was decided in a manner which was not proper.
And if he does it knowingly.
Yes.
Not unknowingly, we may decide cases wrongly. Okay, I don't know.
Any consideration, any knowing consideration.
So there's an element of mental mens rea, as in the criminal law we say. It's not just your act, it's your mind. You are yourself later saying it.
Mr. Makhloom, there are a couple of questions.
My lord, yes.
Number one, I mean, I'm still at the opening of the door thing.
Yes, my lord.
And 186. So your proposition is that once an appeal is decided, review is decided, through 186, a question of law could possibly be regarding a decision that the process adopted in arriving at that decision was flawed, was unjust. Now, we would probably require you to tell us what would be that injustice, categories of that injustice. One is bias, as you just mentioned, and what else? Now, my second question would be, first of all, I mean, I'd like to know the list of all those injustices that could creep in as a process that would affect the judgment, one. And number two, would that not then entail an inquiry by this court to determine that injustice? Are we in a position under 186 to inquire, because that might entail recording of evidence, to come to that conclusion that there was injustice in the process of arriving at that decision? And I don't know, I mean, I think there are decisions which say that 186 does not entail, because we just have to answer a question of law. We're not going to get into evidence and inquire and figure out whether at all, you know, if it requires evidence. So these are the two questions. First of all, what are the injustices that you think would affect the process? And then if that requires recording of evidence, how do we go about it?
My lord, the known categories are such, and I'm restricting myself to cases even internationally where a final decision was made by a court of final appeal and thereafter a remedy has been provided. Not in a review jurisdiction, but in a subsequent jurisdiction. In subsequent issues raised, either like they were raised in the House of Lords through a common law application. Surprisingly enough, even in the United States, which is otherwise a country of statute law and the Constitution, such a remedy has come in through again the common law jurisdiction of the writ of coram nobis, correcting the errors which exist.
But if you could just list, it's very important to understand that if at all this argument goes through, that we're going to look at a judgment that stands settled by this court through the process being, what are those grounds?
My lord, the process goes back to the old principles of natural justice.
So,
Odi alteram partem and
okay.
nemo
No, I think
judex because
it was not a question of not being heard. I think let's, as far as these cases, there may be cases where inquiry may be required. Is this one of those cases? I mean, if one of the judges says something, either you say he is not saying this thing, that's a different thing. And it was reported widely, recorded everywhere, and he could have said, I've been misquoted, I've been whatever, that he didn't do. He was a retired judge, so he could come on TV and say whatever he wanted to say. So that aspect, maybe there are cases which require inquiry, but probably this may not be one of those.
My lord,
so I'm back to really question of reopening the issue on rendering an opinion to the president, whether and as far as the effect is concerned, I think effect, suppose it was a unanimous decision, suppose. And even if you take out one judge, it won't make any difference to the judgment. But here, it hangs by a thread of one vote. So it would make a material difference if they all were quitting for whatever wrong reason or right reason, or they were all convicted, or even if you remove one, it won't make any difference to the judgment. But here, it will have a practical significance on the judgment, and we're left with what the learned judge had subsequently stated that how he acted. So there may well be other cases where you cannot do it because you would require an inquiry. Do we require an inquiry? In this case, is a question for you to address.
My lord,
I will add to the question. Suppose if we believe that there was a bias, what was the question of public importance for the government to ask the court to give answer, number one. Number two, whether, since this judgment has been implemented, whether this question cannot be looked into in some other case, some regular case during appeal, in any other case. So what is the public importance matter in it?
My lord, the second question first. Insofar as the judgment is concerned, whether your lordships can look at it in appeal, obviously your lordships can. And your lordships can overrule it. It happens all the time. Your lordships have very recently done it in a case of which the reasons came out yesterday. But that's a different issue. The question is whether it's a question of public importance. There I would say that, my lord, once the president has framed the question and sent it to your lordships, the public importance aspect is decided by the president. But coming back to the question of my lord, the Chief Justice, my lord,
and just if I may just add one more thing to it before you may also incorporate that. Can we ignore the elephant in the room? Martial law. Can we really ignore that? Can we not take that into, can we not factor into that? I would, a trial where the violator of the Constitution had a vested interest in the matter, the prosecution, he becomes a prosecutor before a court of law under martial law. It cannot be categorized as a normal court under normal circumstances, at least. So can we just completely overlook this and go into the finer aspect of the matter, or this would be a crucial factor to consider?
My lord.
And had they taken oath under PCO at that time?
Yes, my lord. Because what happened was PCO came in 1981, as your lordship will recall, 24th March 1981.
So
but an oath was immediately administered after 5th July 1977.
So even if it's not an oath, it's a physical violence part of it.
And the oath is mentioned in the Begum Nusrat Bhutto judgment, particularly by my Lord Mr. Justice Qaisar Khan at that time. My lord, may I take it a step further? Your lordship says that if it was a judgment, let us assume it was
we question. We don't say we question.
My lord, yes.
Okay.
Well, as your lordships observe, that if it was 7-0, and it later on turned out that one of the judges' conduct suffered from a reasonable apprehension of bias, I would respectfully submit that even then it would be a case for your lordships to declare that it was an unsafe judgment. And why, my lord? Because your lordships' deliberations are not public. One does not know what happens after your lordships have heard arguments in a case and go back and deliberate. Who was how powerful in terms of persuading the others and what role he played? It would be difficult to determine that. So once reasonable apprehension of bias is established in
But you are entering into the realm of conjecture. I'm grounding myself on the realm of facts.
My lord, yes.
The fact is simple. Yes, you may, one person may be so persuasive that he changed everyone else's view, but that's conjecture. This I know as a fact that he said something. So, yes, you're completely right, but why go into conjecture when we have a fact? There may be other cases we may have to conjecture that way. That may well be. But do we need to do so in this case?
Not really, but I was responding to a hypothetical assumption. My lord, if your lordship looks at the High Court judgment, in the High Court judgment, it was 5-0, which was later on upheld by the Supreme Court. It was 5-0, written by...
I think let's stay clear of the High Court judgment. Let's stay with the Supreme Court because that will open another realm altogether.
Your lordship will find...
Because we are looking at the judgment of the Supreme Court.
Your lordship will find, it's up to your lordships, but your lordship will find that there are far more categoric statements by the sitting judges of the High Court of that time and by judges of the Supreme Court, not only Mr. Justice Naseem Hassan Shah.
No, but then the other question will arise, then what were the judges of the Supreme Court doing?
Was that also raised as a ground before the Supreme Court?
Could you, then
no,
you
my lord, it
effectively are re-arguing the appeal.
And an application was moved before the learned judge himself requiring Mr. Justice Maulvi Mushtaq Hussain to recuse himself.
Right.
And he did not recuse himself.
I think there's an added thing that the trial took place in the High Court.
In the High Court.
Ordinarily, it would have been held in the Sessions Court. Now, we need to, I think later they will address us on the point whether it was by consent or opposed, because that also has to be clarified.
My lord, much better people will clarify that to your lordship, but my cursory examination of the record suggests that the order was made even without a notice to the accused, transferring it from the Session Court to the High Court, constitution of a 5-member bench, and cancellation of the bail earlier granted to him.
So sorry again to nudge you, but can you just focus on this aspect? We have not lost sight of this. These are very valid questions, but we want more from you from this constitutional aspect.
My lord, constitutional aspect, the submission is that the tests which your lordship have evolved in the constitutional domain
So you have primarily referred to one judgment from our jurisdiction, the Governor General's reference. The other one is the Pinochet judgment.
Pinochet judgment.
If you can sort of give us more citations on this aspect.
If your lordship will see,
has there ever been a case where a judge later confesses or admits that he did wrong? Is there such a case?
my lord, in the common law jurisdiction, I have not come across one.
Okay.
So this is a first case, and when confronted with the first, like your lordship noticed in Pinochet, the court created a new category. Prior thereto, the category was don't be a judge in your own cause, don't have a financial interest. To that was added a category that no other non-proprietary interest will also disqualify.
Justice should also be seen to be done.
And
that principle.
And
yes.
that is where your lordship will find, I'm very grateful to your lordship for that observation. In the first judgment of Lord Wilkinson Brown, he goes back to the case of R versus Sussex Justices ex parte McCarthy, and he says the test remains the same. The justice must not only be seen, must not be done, but also be seen to be done.
No, Mr. Makhdoom, now, so as I understand, one could say that, I mean, your argument is that this judgment is unsafe because of the bias, because of the pressure. That's one document or one submission would be the video and the recording of one of the judges. What about the minority judges? Were they hunted later on and somebody had to leave the country? Is that
My Lord, Mr. Justice Ghulam Safdar Shah
how do we understand that now?
leave the
You see,
country.
this is the larger picture.
Yes, the larger picture, my Lord.
Martial law, Judge, Justice Wahiduddin. So there are a number of other factors which come
Can you
in.
tell us those other factors that were circling around at that time? when this-
May I take your lordships, give your lordship the trouble of taking a look at some select portions which I have highlighted
Yes.
of the transcripts of the interviews of Mr. Justice Naseem Hassan Shah and Mr. Justice.
This booklet?
Yes, my Lord, the one which was handed over just now.
Ji.
If your lordship will see.
Who were the minority judges, by the way?
My Lord, in the Supreme Court, the minority judges were Mr. Justice Muhammad Halim, Mr. Justice Ghulam Safdar Shah, and Mr. Justice Durab Patel.
Right. Any interviews on their part or any documentation?
My Lord, not really.
Durab Patel, there is.
Durab Patel Sahab, there is. I
Your
haven't been,
testament उनकी क्या किताब
My
है?
Lord, testament of a liberal में बात इतनी clearly नहीं आती है, लेकिन there is, and Mr. Salahuddin Ahmed informs me, and I also recall that, there is an interview done by PTV, which is not on the YouTube in its entirety, but is available in the PTV archives. That is a full interview of Mr. Justice Durab Patel.
There is also a book written by General क्या नाम है उसका?
Kishti?
Aslam Beg,
Yes.
who also said about this case, revealed some facts about this case.
My Lord,
So what happened to these judges? The minority judges were there except Justice Safdar Shah left the
except
country?
Justice Safdar Shah, Mr. Justice Durab Patel refused to take oath under the PCO of 24th March 1981 and thereby ceased to be a judge of the Supreme Court.
And Halim?
Halim Saab took
He would
oath
have been
under...
the Chief Justice of Pakistan.
Yes, Mr. Justice Halim took oath and became the Chief Justice
Should
of
his
Pakistan.
photograph not adorn this court?
And my Lord, then the list will be too long.
Many of those who did not become Chief Justices because of constitutional
उसमें तो
abrogations or subversions.
उसमें भी कई आ जाएंगे.
ज़्यादा लंबी लिस्ट नहीं है, छोटी लिस्ट.
हाँ, उसमें वही वजीउद्दीन साहब भी आ जाएंगे because he would have become Chief Justice.
रशीद रज़ी साहब भी शायद आ जाए.
जी, अगर वो हाई कोर्ट से all the way लेकर आए तो बिल्कुल. Sir, this is, my Lord, the volume just handed over today. If your Lordship may see tab 6.
जी.
My Lord, this is a book.
Which number do you want to?
My Lord, tab 6.
6.
Tab 6. This is a book by a senior journalist, Mr. Suhail Vadaich. जस्टिस मुनीर से जस्टिस इफ्तिखार तक अदलिया के उरूज ज़वाल की कहानी.
ये अगर
नहीं सर, ये उन्होंने इंटरव्यूज इसमें कलेक्ट किए हुए हैं. इसमें दिस इज नॉट हिज कमेंट्री.
Okay.
And one of the first interviews, I think, my Lord, if your Lordship takes a look at this tab 6, this is
which page on tab 6?
the very first page. Immediately your Lordship will see the first page 91 at the top. Chief Justice of Pakistan, Justice Naseem Hassan Shah. It's his interview, and this is one of the first.
पढ़िए, ये इंटरव्यू एक तारीखी इंटरव्यू है.
जी सर.
इसमें पहली बार
जस्टिस नसीम हसन शाह ने भुट्टो की सुप्रीम कोर्ट में अपील पर अपनी राय जाहिर की, जिस पर कई कानूनदानों ने इनसे इख्तिलाफ किया और फिर लंबी बहस चलती रही. उन्होंने इस इंटरव्यू में भुट्टो की फांसी पर अफसोस का इजहार भी किया और कहा कि भुट्टो ने एटमी प्रोग्राम की तैयारी में बहुत बहादुरी का सबूत दिया. गर्ज के इस तरह की बहुत सी हैरान कुन.
ये तो एक कमेंट है.
Yes, sir,
Actual interview.
If your Lordship may turn to the interview, that is from page 93 onwards. I will not read the entire interview.
Just tell us where the relevant portion.
96 to start with. Page 96.
जी.
सवाल, भुट्टो की फांसी के बारे में कुछ बताएं. इस बारे में लोग जानना चाहते हैं. डॉक्टर नसीम हसन शाह, वो मुकदमा तो पहले हाई कोर्ट में चला, वहाँ 5 जज साहिबान ने वो मुकदमा सुना। उस वक्त मुकदमे के हवाले से छोटे मोटे वाक़यात भी होते रहे। भुट्टो साहब समझते थे कि शायद मुझे पूरी सहूलियात नहीं दी जा रही। जस्टिस मौलवी मुश्ताक जो उस वक्त चीफ जस्टिस थे, उनकी और भुट्टो साहब की आपस में थोड़ी बहुत नाराज़गी थी और मुश्ताक साहब भुट्टो से खुश नहीं थे, क्योंकि भुट्टो साहब ने 8 सीनियर जजेस को छोड़कर जस्टिस असलम रियाज हुसैन को चीफ जस्टिस बनाया था, इसलिए कुदरती तौर पर उनकी टेंशन थी। फिर लॉर्डशिप टर्न्स द पेज, सवाल क्या पाकिस्तान की अदालती तारीख में कोई
Can we do something more direct?
My lord, then if your lordship turns the next page with 98, लेकिन जस्टिस मुश्ताक के भुट्टो से इख्तिलाफात क्या थे, क्या इस सूरत में उन्हें समाअत करनी चाहिए थी। फिर जस्टिस अनवारुल हक पर भी भुट्टो के इतराज़ थे। डॉक्टर नसीम
मगर ये आप इंटरव्यू कर रहे हैं नसीम हसन शाह से,
जी,
वो अपने मुतालिक बात बताएं ना, दूसरों के तो छोड़ें ना।
दूसरों के बारे में वो कहते हैं अगर वो मुकदमे की समाअत ना करते तो
अपनी बारे में बताएं ना।
एंड देन अगेन इट्स अबाउट मौलवी मुश्ताक।
नहीं वो छोड़िए ना, अपने बारे में बताएं।
100
उन्होंने कहा कि मैंने गलत फैसला किया
इस इंटरव्यू में, नॉट दैट।
फिर इसको छोड़िए,
इसको छोड़ देते हैं। जस्टिस असलम रियाज़ इंटरव्यू इज ऑन द नेक्स्ट पेज, पेज 151, and again I have highlighted the relevant portions.
Was he on the bench?
He was not on the bench. He was not put on the bench. He
So why are we reading this?
My lord, just to point out, he says some things about Maulvi Mushtaq Hussain and how benches were constituted. And why he was not on the bench, he says.
Page 100 पे question relevant.
Page 154.
Page 100 पे question relevant है, जिसमें वो सवाल जनरल ज़ियाउल के साथ आप कैसे ताल्लुकात थे?
जी सर,
Minute of this interview.
जी जी, उसमें वो बिल्कुल कहते हैं कि उनको जनरल ज़िया निकालना भी चाहते थे, पर उनको जस्टिस सलीम
उन्होंने
ने
कहा
बचा
कि ये
लिया।
मेरे कंट्रोल में है। आखिरी लाइन देखें, जस्टिस सलीम ने ज़ियाउल को यकीन दयानी करवाई कि ये मेरे कंट्रोल में रहेगा।
जी जी,
तो हलीम साहब तो एक्विटल जजेस में हैं।
जी जी, एक्विटल जज थे।
लेकिन वो कंट्रोल में,
I don't want to introduce secondary evidence. प्राइमरी पे रहे ये,
लेकिन वो कंट्रोल में नहीं रहे हलीम साहब।
जी सर,
नहीं ये देखें, ये साफी की ओपिनियन है और ये सेकेंडरी सोर्सेज हैं। प्राइमरी सोर्स हो गए जज ऑन द बेंच।
Aslam Riaz Hussain Sahab explains, I will not read it, on page 154 why he was not included in the bench. Then page 157.
नहीं हम ये बातें
How the benches were, your lordship was inquiring about how benches were
अब ये
manipulated.
मेमोआज में आ जाए ना, जो ये खुद कह रहे हैं, इधर कोई चीजें तो
जी सर,
बताइए।
उस पे आ जाते हैं। That in the memoirs, if your lordship turns to the memoirs, your lordship will find that in tab 8.
जी, page 186.
Yes, my lord. Page 183 से appeal against conviction, I put in that entire sub-chapter over here. But if your lordship turns to page 186, and this is important, my lord, about the influence on constitution of benches. And this is direct, what happened to Mr. Justice Naseem Hasan Shah himself.
ये तो बेंच की बात हो रही है।
Gee, but how he was included. Mr. Bhutto filed an appeal before the Supreme Court against the death sentence. At that time, I was still an ad hoc judge in the Supreme Court. The possibility of such an appeal coming up for hearing before me was remote. Such important matters were never placed for hearing before an ad hoc judge, and it was normally a bench of permanent judges of the Supreme Court which would hear them. This normal practice was not followed in this case. It was sometime in the beginning of April 78, while I was getting ready to attend an evening function, I was informed that Mr. Justice Mushtaq Hussain, Chief Justice of the Punjab High Court, and Mr. Sharifuddin Pirzada, Attorney General, had come to see me. I went to the guest lounge to meet them.
It's not relevant.
Yeah, this shows, my lord, your lordship's question was.
नहीं तो okay, fine. तो you can't force a judge to be on a bench. He could have recused himself.
That he was put on the bench.
No, he's making it sound that he was under compulsion to be on the bench. He could have simply recused himself.
That's true, my lord. And page 199. Lordship, what was the effect?
वो जैसे इफ्तिखार जो अहमद साहब जो जर्नलिस्ट हैं उनका इंटरव्यू है ना,
वो भी पढ़ा
डायरेक्ट बात करें
जी, उस पे आ जाते हैं। 199 सिर्फ देख लें। 199, page 199 in the same tab.
Yes.
No accused ever had more favorable judges, and but for retirement of one and sickness of the other, the panel was in his favor. Your Lordship said how
A favor could be that, okay, I was in your favor, but there was so overwhelming proof I had to do this. So favor would be washed away then. Let's go direct to the interview of Mr. Iftikhar Ahmed.
My Lord, yes, that interview is also, I have filed that, my Lord. That's before your Lordship. This is tab 7.
मैडम के पास नहीं है ना, मेरे को चाहिए.
जी.
If your Lordship turns the page in this one to where it directly confronts the issue. This is page 8. The paging is at the foot of the
ये
page.
पढ़े ना, ये बात आई.
इफ्तिखार अहमद
जी.
आप जुल्फिकार अली भुट्टो केस में मौजूद थे. जस्टिस नसीम हसन शाह जी. इफ्तिखार अहमद, आपसे अगर पूछा गया जाए कि क्या पाकिस्तान की अदालती तारीख में कोई ऐसी मिसाल है कि महज मशवरे की बुनियाद पर किसी को फांसी दी गई है?
एक सेकंड. It is tab 7.
Tab 7,
page 8 of tab 7.
Paging is at the foot of the page.
Tab 7 लाल वाला है. जी. लाल वाला.
अब पे क्लिप 4 लिखा हुआ है.
Clip number 4 है.
Clip number 4, page number 8. आपसे अगर ये पूछा जाए कि क्या पाकिस्तान की अदालती तारीख में ऐसी कोई मिसाल है कि महज मशवरे की बुनियाद पर किसी को फांसी दी गई है? जस्टिस नसीम हसन शाह, जी हाँ, मेरे ख्याल में मशवरा तो नहीं था. इसमें तो वो था कि इनका ऑर्डर था कि वो यानी अपने सबॉर्डिनेट्स को कि उसको रजा कसूरी को ख़त्म कर दिया जाए, तो लिहाजा मशवरे की और बात होती है और ऑर्डर की बात और होती है. वन क्वेश्चन डाउन माय लॉर्ड. मुल्क का वजीर आज़म हूँ, आपके सामने पेश हुआ हूं. मैंने आपको प्रमोशन नहीं दी, आपको बिठा दिया गया है. मैं कहता हूं आप मुझसे इंसाफ की तवक्को नहीं है, तो आपको क्या करना चाहिए था? जस्टिस नसीम हसन शाह, तो मेरा नहीं ख्याल कि किसी को उन्होंने कहा कि ऐसी बात की मुझे तवक्को नहीं, बल्कि उन्होंने तो हमेशा कहा कि मुझे सुप्रीम कोर्ट पर पूरी. इफ्तिखार अहमद, मौलवी मुश्ताक की बात कर रहा हूं. मौलवी मुश्ताक साहब को जुल्फिकार अली भुट्टो ने कहा. जस्टिस नसीम हसन शाह, जी हाँ, वो मेरे ख्याल में मौलवी साहब की ज्यादती थी, क्योंकि यानी वो बहुत ही जबरदस्त आदमी थे और वो भुट्टो के दुश्मन थे और उनको चाहिए था कि इस केस में ना बैठते तो बेहतर था.
वो उन्होंने जो कहा था ना, प्रेशर था मुझ पे फौज का, वो किधर है?
सर, दैट इज अर्लियर ऑन, दैट इज इन द जनरल कॉन्टेक्स्ट एज टू व्हाट हैपेंस. दैट इज नॉट स्पेसिफिक टू दिस केस. And I'll take your lordship to that, but if your lordship may just complete this, page 9. सर, आपने एक जगह पर अपनी राय का इजहार किया कि आपने कहा कि भुट्टो केस की समाअत के दौरान मेरी यानी आपकी जाती राय थी कि भुट्टो की सजा में कमी हो सकती है. जस्टिस नसीम हसन शाह जी, इफ्तिखार अहमद, और इस सिलसिले में उनका केस बड़ा मजबूत था. जस्टिस नसीम हसन शाह, हाँ बिल्कुल. इफ्तिखार अहमद, मैंने भुट्टो के वकील याया बख्तियार से पूछा कि क्या मौत की सजा में कमी के बारे में दलाइल देना चाहते हैं, तो उन्होंने इनकार कर दिया. जस्टिस नसीम हसन शाह, ठीक. तो साहिब जज साहब, जब आप कन्विंस थे, तो जब आप फैसला दे रहे थे, तो डिसेंटिंग नोट नहीं आपको लिखना चाहिए था कि इस हद तक सजा ना दी जाए. जस्टिस नसीम हसन शाह, जी हाँ, हो तो सकता था, मगर वो जो इनका वकील है वो कहता है मुझे सजा की कोई परवाह नहीं, मुझे तो एक्विटल चाहिए. मैं समझता हूँ भुट्टो यानी जो है इफ्तिखार अहमद, सर आप भी डिसेंटिंग नोट तो दे सकते थे ना. जस्टिस नसीम हसन शाह, दे तो सकता था, मगर यानी मेरे ख्याल में उसमें कुछ थोड़ी सी हमारी भी कमजोरी है और कुछ उसकी याया बख्तियार की भी थी. यानी जिद, उसने हमें एक किस्म का नाराज कर दिया. इफ्तिखार अहमद, अच्छा, याया बख्तियार ने आपको नाराज कर दिया, लेकिन सर आप खुद तस्लीम करते हैं कि भुट्टो को ये मिलना चाहिए था, बेनिफिट ऑफ डाउट मिलना चाहिए था. जस्टिस नसीम हसन शाह, जी हाँ, ये तो अगर आप इसको जाती तौर पर तस्लीम करते हैं जैसा आपने माना, अगर आप डिसेंटिंग नोट लिख देते तो आज पाकिस्तान की तारीख मुख्तलिफ ना होती. पता नहीं मुख्तलिफ होती या नहीं होती, मगर कम अज कम उसकी जान बच जाती. So that's.
But this really putting the blame on counsel. I mean, if counsel doesn't argue properly or whatever, even if we accept that, there are two punishments. We are going into punishments.
Yes.
The person may not insist on it because he may think I've got such a ironclad case. Why should I seek for lesser punishment? That would involve, in a way, admission on my part that it's applicable. And very well the council may not take that thing, but it doesn't mean that the judge should not consider it. That's a different thing altogether. So as perfectly as tactical ploy, but council will say absolutely not. I'm not interested in lesser punishment. I want a clean acquittal. So why should that be held against counsel or the accused? I don't see the logic of this argument.
But my lord, the only explanation on the transcript of this interview, I am not aware whether otherwise there was one, is that he says कि उसने हमें एक किस्म का नाराज कर दिया था.
हाँ, वो बात आप कह सकते हैं.
जी.
नाराज कर दिया तो या सुनना छोड़ दें या फिर भी इंसाफ करें.
And in his,
हम भी नाराज हो जाते हैं कभी. ये तो मतलब नहीं कि फैसला उलट दें. कभी कभी वकील की सजा उसको तो ना मिले ना मोकल को.
सब ये अपील में उन्होंने अल्टरनेटली मिटिगेशन के बारे में कहा है या नहीं कहा. ये तो ये कह रहे हैं ना कि हमारे सामने नहीं कहा. अपील में नॉर्मली एडवोकेट जो हैं वो एक अल्टरनेट रेमेडी लेते हैं. तो क्या वहां मिटिगेशन के बारे में कुछ कहा गया कि ये नहीं हो सकता?
sir, it appears from Mr. Justice Durab Patel's judgment in the review note that this was an argument made for the first time in the review petition.
नहीं, मेन माय लॉर्ड पूछ रहे हैं कि मेन जो जजमेंट था.
अपील में क्या लिखा?
In the review it appears that they refused to look at it on the ground that this was not a submission made in the main appeal. So the review judgment suggests that this submission was not perhaps made in the main appeal.
सबमिशन करना समथिंग एल्स.
जी.
क्वेश्चन रहते जब भी अपील लिखी जाती है
जी सर.
तो उसमें एक अल्टरनेटली ये कहा जाता है कि इट्स नॉट एक्सेप्टेड केस फॉर कैपिटल पनिशमेंट. उस पर मिटिगेशन की सर्कमस्टांसेस बता दिए जाते हैं. मैं वो कहता कि अपील में तो ऐसा है. ये तो कहते हैं हमारे पास सबमिट नहीं किया. वो तो कह रहे हैं लेकिन उसमें है या नहीं है. बस ये क्वेश्चन.
Lord, insofar as I am aware, no.
Makhdum sahab, such like submission pleas are made in the submissions before the court. Alternate remedies asked from in the court.
Yes, yes.
उसमें लिख नहीं देते because सारा केस फिर उधर चला जाता है कि alternate remedy.
ये क्रिमिनल अपीलें आप देखें 4 लाइनें की तो लिखते हैं, कुछ लिखते ही नहीं उसमें. Unlike civil pleadings, but the fact remains that the judge has to consider it. If a lawyer doesn't take this plea, actually we do the whole thing very lopsided in Pakistan because every criminal case has two components which we tend to overlook. One is conviction and one is sentence. I mean, in the West, you have a separate date of hearing of matters for sentencing. Then that person then pleads, these are the mitigating factors. Here we roll it all up into one. And this is the duty. I don't think it's a duty, even if the council doesn't take it, wherever it's the duty of the judge to see if mitigation is there. Because then you err on the side of caution and you give the lesser sentence as opposed to maximum one. And then you have to justify the maximum one because it was a horrendous crime or whatever you want to say. So that's the general way it should happen. Otherwise, criminal appeals don't say much. I mean, if you read criminal bail applications, they don't say anything.
Sir, I have never read it myself, but I have heard from senior members of the bar, some of them are no more, that one of the most celebrated criminal appeal lawyer before the Lahore High Court, West Pakistan High Court at that time, was the late Mr. M. Salim, whose entire murder appeal used to consist of one sentence: the judgment of the trial court is opposed to the facts of the case and contrary to law. And M. Salim.
Yeah, we also see the same pattern still.
Because it's a first appeal and all the facts and the law have to be examined by the High Court, so there's no point in going through it, and that's how it was done. There was a printed form, I'm told, of the Lahore High Court, and he would add only one sentence.
Is this the only case where the High Court had heard a case of murder as a court of first instance?
My lord, in Pakistan,
is there any other precedent? I'm not aware.
There may have been other, but in reported judgments in Pakistan, I have not come across. But that may be on account.
So we just raise this question. Maybe some other council can also address it. whether this was the one and only case of its kind which was heard by the High Court. Because, I'm more looking at the totality of the matter as opposed to individual things.
Yes, my lord.
Martial law, High Court trial, one right of appeal lost. You saw all these factors, 3-2 split decision. I don't know of any other, and is there any other case which has been, you've given capital punishment on a split decision? These are all these other factors which come into play. Then, as my lord observed, that some of the judges were persecuted.
And Justice Durab Patel, when your lordship summoned that transcript from PTV, says that in a split decision like this, it doesn't happen. He says that even in his review, very short.
Even if he doesn't say it, that's a general principle of law.
Even in the review judgment, my lord, which is a one-page judgment where he concurs with the majority, but he says that this is a point which has been highlighted, and from India a judgment has been produced where the split was 2-1.
But unfortunately, he was part of the review of a unanimous review.
Yes, my lord. But
that is what's troublesome also. All 7 were unanimous on the review.
My lord, but if your lordship reads the review judgment of review opinion of Mr. Justice Durab Patel, there's a very short opinion, about a page and a half.
I've read it.
Yes, my lord, it says very simply why he's there. He said Mr. Yahya Bakhtiar has argued.
He's put all the blame on the council.
No. He says 2 things, my lord. He also says that while arguing this case, he has been unable to persuade the majority to change its mind. So the outcome remains unaffected. And
the outcome to sentence doesn't remain unaffected. There can be the capital punishment, or there can be imprisonment for life.
On that, my lord,
I think the basically determining factor is it the duty of the judge or is it the duty of the council? In my opinion, it's the duty of the judge to look at it.
On that, his view is, with which Mr. Justice Ghulam Safdar Shah and Mr. Justice Muhammad Halim agree, that this is raised for the first time in review, and he mentions that and he moves on. But his basic thrust of his reasoning appears to be that you have failed to persuade the majority, so if we just reiterate our views earlier expressed in dissent, where would that lead to? The judgment would stand.
I'll just tell you a simple thing. This is a criminal appeal.
Yes, ma'am.
What are you saying? Set aside the judgment. Basically, you're saying that in a criminal appeal. You're not saying, let the judgment hold, but give me a lesser sentence. I mean, you're not really saying that in a criminal appeal. That's only a matter of law, settled law, whether you will grant a lesser sentence or not. For the judges, with the greatest respect, to say that it was not argued before us, I don't think that is probably correct approach, because we always look to mitigation, whether it's, whenever I've heard of cases, whether it's argued or not.
My lord, correct.
Unless it's a case where already the lesser sentence has been given. Then the burden shifts. Then the state or the complainant may come for enhancement of sentence. There the burden he has to plead. That I'm standing by the judgment, but please enhance it. There was no justification for giving the lesser sentence. That would be altogether a different category of case for enhancement. This, you are here, if he set precedent, I don't know of any other court which has followed this precedent, that it's for the council to plead lesser sentence. If we uphold the judgment, why should he do it?
Outside, as your lordship observed, it's different because the judge.
Pakistan, we're talking about.
But because over there, my lord, the judge of facts and.
Like I told you, there are 2 separate hearings altogether.
Yes, because the conviction is for the jury, and once the jury has convicted, then the sentencing is for the judge, and it's the sentencing stage that the plea of mitigation comes in. And simply because you have pleaded for acquittal doesn't mean that you cannot put in a plea for mitigation in sentencing. But because of the 2 stages, it is possible to separate that. Over here,
I'm going one step further. I think it's the duty of the judge to consider it in a capital offense. Not maybe in other offenses, but definitely in a capital offense.
My lord, if following that line of observation, the submission is...
I may be wrong, you can correct me.
My lord, the submission is that it is all now, all these requirements of natural justice and fair procedure get merged into one simple doctrine: the duty to act fairly. The duty to act fairly by the judges, and where their duty is in any manner affected, then it is said that the case can be reopened.
And the question,
Can you go back to the constitutional point and let's finish that?
My lord,
question was asked, Mr. Makhdoom, question was asked by that person from Naseem Hassan Shah, कि क्या आप ये खुद नहीं कर सकते? तो उन्होंने कहा कि ये मुद्दई सुस्त गवाह कोई आया नहीं.
जी, जी,
So this
बिल्कुल.
is the duty of the judge to consider, to deliver justice.
वो भी उन्होंने कहा है वो थोड़े से नाराज हो गए थे.
ये अगर एक एक्सट्रैक्ट अगर जनरल असलम बेग की बुक का एक्सट्रैक्ट आई थिंक इट इज रिलेवेंट आपको ये मिल जाएगा अगर ये पढ़ ले इज आल्सो आई थिंक रिलेवेंट इन दिस केस.
And Makhdoom Sahab, was he talking for himself के नाराज हो गया था, or he was talking for the other judges also कि सब नाराज हो गए थे?
Your Ladyship, it appears that he was talking about himself, but I have not read the entire chapter of that book, which I have put in, authored by the learned judge himself. He says that there was a feeling originating from the Chief Justice that the bench is splitting along provincial or lines, and therefore the Chief Justice sent him as an emissary to Justice Durab Patel that if you agree, we can all agree to a lesser sentence. That is not at the review stage, my lord, that is at the appeal stage. And he says, longish discussion with Justice Durab Patel. He said, no, I will decide what I think. I have to decide according to my conscience. You do whatever you think. Right?
There will come another problem. ये भी जरा आप ज़हन में रखिए. A judge retires. He may well be pursuing a political career.
Sir.
आप ये बयान तो देते कि आपने गलत फैसला किया था.
By then he was probably 90 or more than that.
So we don't want to just go on these sort of flimsy matters of what a person says upon retirement. We want to be more grounded on facts. What were the facts? I mean, आप ज़्यादा बात नहीं कर रहे हैं मार्शल लॉ की.
My lord, if your lordship takes a look at the facts, I am not mentioning those facts because those facts are now all part of our collective memory. Your lordship,
it's not part of a collective memory. They have to be reiterated.
Your lordships, in the first round, different bench sharing it, a number of books were handed over to the amici as well. There's the book by General Faiz Ali Chishti.
ये सब चीजें उस पे फैसले होने लगे तो सारे जजमेंट्स उड़ने लगेंगे.
नहीं,
किसी जज ने रिटायरमेंट पे आके ये कह दिया वो कह दिया.
He was the right-hand man of General Ziaul Haq, and he says that Ziaul Haq had come to the conclusion that it has to be his neck or mine.
So that's
he
the
doesn't
have to say it.
That's the background. And your lordship will find that in Mr. Justice Aslam Riaz Hussein's interview, he mentions the same thing as well. That's already on the record before your lordship.
Can we go back to case law, President?
My lord, case law, Pinochet I have cited, and may I just briefly say what Pinochet stands for. Pinochet stands for that if the judge has an interest in the matter, that interest doesn't have to be pecuniary, that this interest doesn't have to be proprietary or personal, that interest is enough, because then the decision cannot be said to be solely based on the evidence on the record. So anything which affects the judicial mind besides the evidence on the record is something which will disqualify. Now, what is the test? The test is not what a 9-member bench of this honorable court thinks. The test is what the man on the street thinks. What is the common perception? Is the common perception that there was a reasonable apprehension of bias in this case? And if that common perception of reasonable apprehension of bias is vindicated by the surrounding circumstances, by journalistic writings, by writings in history, then that all gives a flavor of what was happening. My lord, bias may not be just martial law. To give your lordship an example.
No, but can we go on?
Yes, my lord. Moving on.
No, the other point would be, can we then open every case on this basis?
No. That's why I'm saying what happens.
Where is the distinction?
Your lordship will find no other case where a sitting member of the bench has cast doubts on its correctness. on account of circumstances other than the evidence in the matter. Your Lordship will find no other case where even decades later a sitting Prime Minister in 2023 stands up before the National Assembly and refers to this decision in the words, and that transcript I have put on the record as well, my lord. That is the speech made on 4/4/2023. That's
Can we not go that far as to say, you know, I am very disturbed by martial law. The minute you start accepting it, everything goes wrong. The minute you stop it, everything goes right. Why can't we stop at that? Why are we not addressing that at all? We're going to finish there is martial law in the country. The judges have been weeded out, selected, chosen, whatever you want to say. A trial of a person, the martial law administrator has deposed. These are not insignificant factors.
Correct.
So why are they not being stressed enough?
My lord, they are, but may I stress them by reference to the case law. For instance, my lord, in US there has been no martial law as such. But the specter of war, where the military is supposed to know its best, has resulted in judgments which have later on been regretted, and in which the convictions awarded have been held to be unsafe, and in which compensation has been awarded.
I want you to.
Yes, my lord.
Sir, we have to kind of, if you don't mind.
No, my lord, we move on to those.
Please don't mind it.
Not at all, my lord. We move on to those cases and you will find.
Because amicus spend time.
My lord, if your lordship will take a look at the volume 1, the blue volume.
Ji.
Your lordship will find in the index, there is an article by Lord Bingham who traces some of the history of some of this case law. I will not read it. I'll just identify. It is at page 116 to 130 of this blue bundle. This blue bundle, my lord, volume 1. Page 116 to 130. In index, it is at number 16.
Lord Bingham was a judge.
And prior to that, if your lordship will see.
Which page are we referring to?
My lord, if your lordship takes a look at the index, page 2 of the index, your lordship will see item number 16.
Tab कौन सा है? Tab?
नहीं, 116 पे है.
Sir, इसमें tab नहीं थे.
नहीं, 116 पे lives of law.
जी sir, lives of the law, page 116 पे है.
There's no index. It says selected essays and speeches.
Index is right in the beginning of the volume, my lord.
Oh, no, but which page should we go to?
116. I'm just referring it to it. I will not read to your lordship.
What do we read from here?
My lord, he points out cases from Liversidge versus Anderson in England to Korematsu and Hirbayashi in United States, where at times of war, the courts made decisions which were unsafe, and when the specter of war had receded, the courts offered correction. In the case of United States in particular, the error was made all the way up to the US Supreme Court, and the correction is made later by the federal court. Those are at 13 and 14.
No, but the correction is made judicially through another judgment.
That is made at...
That's another jurisdiction altogether.
My lord, that's a common law jurisdiction again.
Another case comes and they correct the earlier principle.
No, in the same case. In the same case, awarding compensation to the same persons whose appeals had been turned down by the Supreme Court.
So it means every judgment passed during the martial law tenure can be looked into.
My lord, your lordships will have to examine.
We have already a bundle of cases, and if you can indulge yourself in this scenario.
Your lordship will find it very difficult to get another case where the circumstantial evidence, both contemporaneous and later on, points the finger that the duty to act fairly was not observed in this case. Your lordship will not find another case. This is singular.
This can be rectified by the parliament.
How will
the parliament has endorsed all those acts of the martial law in the parliament.
My lord, he could have...
This is for the parliament. Why they are not doing so?
He could have been pardoned by the president at that time. That was Ziaul Haq. Can he be pardoned now?
This is what has been discussed by Mirza
What is the
Aslam
answer to that question?
Well, what, my lord?
Post to, after death pardon.
My lord,
Have you considered it or not?
my lord, it is for the Attorney General to inform your lordship whether that was considered or not.
No, legally can it be done or no?
नहीं मखदूम साहब मेरा भी एक सवाल है. Supposing this case, Mr. Bilawal Bhutto, this case is decided in their favor, and this murder, this is considered as a murder. Will the court allow Mr. Bilawal Bhutto and Zulfikar Ali Bhutto Jr. to ask for qisas?
Your ladyship, in other jurisdictions, and those are the two cases I would refer, the courts themselves have awarded compensation if they wanted to. But over here, it appears to be nobody's case that they are seeking any compensation.
I think here we have a very limited presidential reference.
Yes, my lord.
To render an opinion on, I mean, I don't even think we can set aside, we have to render an opinion whether it's good case law to follow. I think that was a question which was primarily referred to.
And the first question, my lord,
what would be the remedy? I mean, what remedy they are going to get from this case if this is decided in their favor?
Your ladyship, remedies are not always tangible. The only thing we carry to our graves is a reputation. And
already this case is not referred to in any criminal cases.
I may put it differently. In the court of the people and in the court of history, this decision has been turned down in any event.
Yes.
It is now before a court of law that whether it squares up with Article 4 of the Constitution and the due process of law. So they are not seeking vindication in the court of history or court of people.
We cannot substitute our finding with the trial court, appellate court, Supreme Court and the review jurisdiction.
My lord, no findings
This
are
is only for the opinion purposes.
My lord, and your lordship's test over here is different. Is your lordship going to provide any relief to the accused in this case? No, he is beyond relief.
It's beyond this.
What is over here, the pivotal question is the public confidence in the fair administration of justice, summed up in a series of judgment that was there a reasonable apprehension that justice was not seen to be done.
So could you just list all your points? Why was this judgment unsafe? 1, 2, 3.
My lord, in my respectful submission, this judgment is unsafe because when your lordship looks at what has transpired since then, your lordship will see that the requirement of due process of law was not observed. I am keeping it at as general a plane as possible. These political, the constitutional, and the judicial circumstances prevailing at the time made a fair trial difficult. The apprehensions of bias expressed not only by the members of the public and journalists and historians and legal historians subsequently.
Was there any
very general, it's very
due
general.
process
You
पे
have to
जो
be
बात हो रही है ना, you have raised first point that due process of law was not followed. So there is a question whether the charge was framed, evidence was recorded, cross-examination was done, statement under section 342 was recorded, whether the defense witnesses were allowed to be produced or not. This is the due process in the criminal trial. You want to say that these steps have not been followed by the trial court?
No, I am not saying that. What I am saying is that the requirement of due process, the pivotal requirement of due process is that the case of any person must be heard and determined in an impartial manner.
Without external pressure.
And by an independent jury.
Was there any external pressure?
My lord, all the materials before your lordship seem to suggest so. And that is why,
What is that material?
my lord, that is why the material is...
That material, I think if you read the extract of the book of Mirza Aslam Beg, it is sort of a confession or
Yes, well,
portion of it.
I'm very grateful for that. I'll read out to your lordship immediately. If your lordship will see,
Exactly, he doesn't.
I'm reading from page 65.
This is 14 head division command.
I was promoted Major General in 78 and assigned the command of 14th Division, which was stationed at Okada. With this command, I became part of the military hierarchy and remained associated with all military matters of the army from 78 to 88. 14th Division was part of 2 Corps at Multan. General Zia ruled the country. Case of ex-Prime Minister Zulfikar Ali Bhutto was in the last stage. Supreme Court awarded death sentence to Bhutto in 79. General Zia asked the Corps commanders to assess the likely reaction of the men in uniform if Bhutto was hanged. Our Corps commander called a meeting of senior officers and asked many questions. All except me said that the reaction would be very mild and that could be controlled easily. I kept listening. When all had expressed their opinion, I sought permission to speak. I said, hanging Bhutto will be a very wrong decision. It will have very grave consequences. It will create political aberrations which will be difficult to sort out. It will be better that Bhutto should be sent to exile. And then points out what Yasir Arafat and others were prepared to do. Corps commander got annoyed and declared the meeting closed. Later he called his Chief of Staff Brigadier Lieutenant General Hamid Gul and asked him to arrange a telephone call to COS. He did not want to see such officer in his formation.
Mr. Makhdoom Ali Khan, can this case that we are hearing be also categorized as a case presenting the Supreme Court with an opportunity to vindicate itself, as well as, I mean, martial laws are not imposed by the military as an institution. It's an individual who does it. Is it not also a good opportunity to vindicate the armed forces as well?
This would definitely...
Could it be categorized as that or not?
My lord, I would.
Because, you know, there must be new beginnings at some stage in our very checkered history. And we are perpetually living in the past. We're not really looking to the future on anything. So, I mean, when I find in law, not on the constitutional aspect, there are problems with the judgments. Major problems with the judgment. It's not just a question of, and when we go deeper into the trial and how it was conducted and how it was resurrected and Justice Shafiur Rahman's report. So what purpose does it serve? Does it heal the wounds of a nation or does it not? Does it not enhance the reputation of the armed forces by drawing a line placing the blame on an individual? And the same applies to this institution. Is this aspect at all to be considered, or this is in the political domain and we should not venture there at all?
My lord, my submission is that it is not in the political domain, because that there should be confidence in the public administration of justice in accordance with the due process of law is a matter of public interest and squarely within the domain of judiciary.
But in a real case, we can always do that.
My lord,
if a real case comes, that's the time when the judiciary is tested.
My lord,
we should make a decision then, rather than going through this 186 process. I mean, there could be cases, there might be cases coming up. That's the time to
No, that goes without saying. We should always do that. But the question is, it wasn't done maybe in this case. What do we do?
We can still do
too
it.
bad. We can say too bad, it's happened. That's one approach. The other approach is be innovative. Okay? But at the same time, don't create a precedent that it is considered now a second review or everyone comes in. So you have to, if you're articulating a proposition that we can go there, then you at the same time you have to open a very narrow door which should not, be used every other day. You did it in that case, you have to do it in this case. So we have to keep that in mind. We don't want to venture into making it like a ground for a second review, then things will never end. We don't want to expand its scope. So you have to tailor-made it. I mean, it may be difficult for you, you're amicus, but can we look to you, or shall we look to Mr. Raza Rabbani as counsel to do it?
Lord, I'm sure they will do a far better job at it because they have got the particular facts
Mr.
of it.
Makhdoom, can I just speaking for myself about the whole matter so far? The question of law at best that you could propose, as you've done, is that we cannot look at the case itself on merits because all stands decided. We can look at the matter from outside, whether at all the process was right. Now, when we say process, the only ground that you might have could be that the judges were not independent and they were biased or they were dictated. Now, the evidence that you produce for that, I mean, it's a big ticket. You see, you're saying that the court was under pressure, was dictated. The only evidence that you come up with is that interview, which interview is not exactly in the context of this case. It is a general statement. Where is the material showing that the judges were under pressure? I mean, we'll have to please identify. That's what we were trying to write. What are those matters? To say that there was martial law, then are you proposing that, as my lord also said that earlier, that all cases decided during martial law will be thrown out of the window, or all the PCO decisions should be thrown out? What are we really doing? It's a very major policy decision that we need to take. Suppose we do open it up only in case of grave injustice that has taken place, which to me translates as the judge was not independent. The only evidence is an interview, which is not in this case. So what are we saying?
Before you address this, can I just tag on a little bit of to that? As far as the general proposition that all murder trials during martial law regimes are therefore held to be void, or whatever word you want to use it, voidable, I would say that probably, or most certainly, in those cases, the commander-in-chief had no personal interest in the matter. So, I mean, we should just maybe keep those two things together. I mean, here it is, okay, if I don't succeed, what about Article 6? Okay, so it's not like everybody, all the other judgments, I mean, Allah Ditta is murdered, whoever else in Mandi Bahauddin would not really matter. What is the interest of the martial administrator to secure one type of conviction or not a conviction? But here is the prosecutor itself fair, the prosecution, who is the...
Look at it with this very narrow window. When your lordship looks at the circumstances of the case, of course there's a general situation, but that General Zia at that time was interested in this case coming out a particular way is now a fact which has been part of a number of history books. That the trial was moved from the Sessions Court, the bail was cancelled, the High Court constituted a 5-member bench to hear it, that the animus of the Chief Justice of the High Court with the accused...
Who cancelled the bail?
Justice Maulvi Mushtaq Hussain.
And it was given by Justice Samdani?
Justice Samdani. So when you connect all these facts, it's a one-off. You will not find...
So, when you are giving these general propositions, if you can restrict them, I think, my lord, like due process of law, I mean, you know, these, if we broaden it up, it may apply to all other cases as well.
No. I'm saying these facts demonstrate to your lordships that there is a reasonable apprehension that the due process of law was not followed in this case. My lord, in the cases where so-called bias or duty to act fairly is alleged, it is impossible for any litigant at all to prove bias. Because
Mr. Makhdoom, one of the amicus who's not here in person, a professor from Oxford, Professor Yasir Qureshi sent a note, and I'm just reading this paragraph, it's very important. He says, in many parts of the world, states are finding ways to remedy past injustices,
My lord.
including in periods of military dictatorship and other forms of unconstitutional rule. This is being done through establishing truth commissions, and he refers to the Brazil National Truth Commission, where people could appear before, granting executive and legislative pardons. So there are other avenues also to rectify this issue.
Yes, my lord. What has happened?
The question is, this is the avenue chosen.
Yes.
Whether this is the avenue available.
Maybe it was not the best avenue. We don't know. Well, we still have to answer the questions.
This may be an opportunity to close door and stop intervention, if any, from outside.
We'll take a short break and we come back.
My lord.
How long would you take?
My lord, I'll try to wrap it up in 30 to 40 minutes maximum, not more.
So at least we should conclude with your submissions. What is it called? Submissions or advice? Oh,
Submissions, my
okay. So we'll take a short break and we'll. What time should we reconvene? 2. Like half an hour break. Is that all right?
Yes, ma'am. That's fine.
Okay.
Lord, the window available to this Honorable Court under Article 186 of the Constitution is indeed a very narrow one. The court is being called upon to give an advisory opinion. An advisory opinion also on an issue which the court has decided and on which the review petition also has been rejected. My lord, your lordships have not in 186, though I gave two examples of 186, one in the case of Rekodik and the other in the case of Yusuf Patel, where in spite of a concluded judgment of this Honorable Court was not averse to looking at the issue under Article 186. In other jurisdictions also, there have been cases, not many, rare, but the court has taken a look at it. The materials are already in the volumes handed over to your lordships and your ladyship on the last date of hearing. One of the cases is AIR 1951, Supreme Court 332.
Is it here?
Yes, sir, in 1A, volume 1A. This is the yellow bundle handed over last time.
Page
332, and there are, particularly if your lordships will see para 334.
Page 3.
332 इसमें तो नहीं, 1 में नहीं है.
ये वाले
1A.
This is 1A. This is the yellow one. One is blue. 1A is the yellow paper book handed over last time.
3.
The judgment starts at page 300, handwritten page 300. It is cited as, the citation is AIR 1951, Supreme Court 332. And the relevant paragraph is paragraph 4.
Which is the page of the book?
My lord, the page of the book is 300.
300. Thank you.
If your lordship may turn to the page of the book at paragraph 334, which will appear at page 395.
There, 186 is 143.
Yes, sir. I feel bound to say with the utmost humility and for reasons given already that the observations of the majority of the federal court in that case went too far, and in agreement with the learned Attorney General, I am unable to accept them as correct exercise.
Which page? Sorry.
I can't
Sir,
find
page
it.
395. 395. It begins at 300. Page 395. The first column on the left. 14 lines from the foot of the page.
Ji.
I feel bound to say with the utmost humility and for reasons given already that the observations of the majority of the federal court in that case went too far, and in agreement with the learned Attorney General, I am unable to accept them as correct exposition principles relating to the delegation of legislative power. So they cast doubt on a judgment earlier expressed. My Lord, in the cases of auction of spectrum licenses, the Supreme Court decided the case in one way, and the matter was then referred to the Supreme Court in an advisory opinion. The citation is reference number 1 of 2012, 10 Supreme Court cases, page 1. The relevant pages are 61 and 65. This is also there in tab 2 of volume 1. This is the yellow bundle, volume 1A, the yellow bundle.
Page 60?
Page 35 of the handwritten page 30.
ये आप पहले भी बता चुके थे
जी सर, ये जजमेंट से पिछली बार सर इंडिकेट किया था कि the materials where your lordship can examine it are here. And 61, if your lordship looks at paragraph 61,
Page कौन सा मुकदम से?
your ladyship, page 99. If your ladyship looks at the 4th line of paragraph 61, for the purpose of the validity of a reference, suffice it to say, dwelling upon an earlier judgment is permissible. And 65, they express same view,
99.
that they are not affecting the outcome of the Liz. While giving this advisory opinion, the outcome of the Liz between the two affected parties is not affected.
So what did they hold regarding after dwelling on it?
They held that that was incorrectly decided.
They said so.
But they said that insofar as that case was concerned, intra-parties, it will not have an effect on the outcome, but the law they laid down is correctly in the 2G cases.
And Article 143 is paramateria?
My lord, yes, and if your lordship sees paragraph 65, they say, if your lordship will see sideline C, paragraph 65, therefore that the fact that this reference may require us to say something different, therefore the fact that this reference may require us to page 100 of your lordship's and your ladyship's paper book, therefore the fact that this reference may require us to say something different to what has been enunciated in 2G case as a proposition of law cannot strike at the root of the maintainability of the reference. Consequently, we reject the preliminary objection.
पूरा पढ़ लेना वही. Consequently, we reject the preliminary objection and hold that this reference is maintainable, notwithstanding its effect on the ratio of 2G case,
Yes, my lord.
as long as the decision in that case, qua the list inter parties, is left unaffected.
Yes. That's why I read it right in the beginning that they caveated it. They said we can express a different view on law. We can do so in an advisory opinion. Intra parties, the outcome of that list will remain unaffected. My lord, in this case, intra parties, the outcome of the list cannot be affected no matter what your lordship say in this case. The man has been, the accused in that
So
case
how
has
is it
been,
different from, you see, I mean, if there's a principle settled in a case, then comes another case later on, and we upset the principle or we overrule the principle, that's the normal judicial process. How would this be different from that one?
my lord, what is happening over here in 2G cases is that this is an issue which the Federation at that time thought may affect the spectrum licenses in future cases as well.
So there was a principle that they wanted.
They wanted the principle to be changed.
In a fresh case, the larger bench could
Could have, but they went, instead of waiting for that to
went through a
happen,
reference.
they went through a reference and the court said we could do that. And the same thing happened in the 1951 earlier case, which I just
Are they in effect saying per incurium?
They are, my lord, saying that, but they are careful to point out that the list between the parties in that case is unaffected.
So per incurium.
For all other purposes.
So what would be the legal effect of the 2G judgment? Would that be considered as an overruled judgment now?
That judgment would be considered as not expressing the correct position of law for the citizenry at large, except where the cases it had become a past and closed transaction.
Per incurium ही हो रहा है
For
ना?
all purposes.
Yeah, am I not
It's been declared as a per incurium through a reference.
That was
That
some
will be judgment in
contract.
personam, because it is inter partes.
or in personam.
Remain in personam only.
That was
That particular judgment, yes.
with regard to any contract between
Yes, my lord.
2G.
Yes, your lordship is absolutely right. With regard to that particular contract of
between the
2G,
parties will
that
not
judgment
be
is confined to as a judgment in personam,
yes.
becoming a past and closed transaction for the parties in that case, but the law of the land is different.
Correct.
My lord, so this was, I had already referred to your lordship to the Yusuf Patel case. I need not go there. My lord, why your lordship was saying point out what are the other examples, but may I just point out that if we put the forms aside and we look at the substance, your lordships have in a number of cases reopened. In your lordships have in a number of cases reopened your concluded judgments.
No, we just did the other day in 62(1)(f), but that's overruling it specifically.
That's overruling. But
Yeah.
may I point out, my lord, even more specifically, your lordship in the pensionary benefits case, the matter relating to your lordship's pensions had been decided. A review petition against that had been dismissed. The
Can you
registrar,
give us a citation?
my lord, the citation of the judgment referred to is PLD 2013, Supreme Court 829.
This is the original one.
No, this is the judgment, which the final judgment in the pensionary case that I have put in. It is tab 3 of volume 3. And it's a long judgment without reading. May I just submit before your lordship what was involved. The pensionary benefits had been decided. A review is filed, a review is dismissed. The registrar of this honorable court says this has come to my notice and writes a letter to the Chief Justice. The Chief Justice constitutes a larger bench, and the larger bench affects the outcome of that already decided case, where the review has been dismissed, by changing that and by declaring that judgment to be per incurium.
So that's a suo motu jurisdiction there.
That's suo motu under
So
184.
then there is a jurisdiction.
No, so what I'm pointing out, my lord, is that your lordships have, in exercise of your suo motu jurisdiction,
That good law.
opened this window. My lord, it has happened in more than one case.
No, is that good law?
My lord, my submission is that under 187, your lordships have the power to do complete justice, but your lordships need a jurisdiction to do that.
Right.
187
You
is
can't-
not the
it doesn't,
jurisdiction
yes.
provision. Now, over here, your lordship is getting the jurisdiction under 186. The window has been opened by your lordships in earlier cases under 184(3). I know, my lord, your lordship was in dissent, my lord, Mr. Justice Mansoor Ali Shah, but where the sacked employees cases came up before this honorable court, there was a review petition and a 184(3) petition. This honorable court, by majority,
Citation?
my lord, I'll just give you lordship the citation.
Well, that's where, I mean, very clearly
It
it's
says 2022 SCMR 1691 with my lord, Mr. Justice Mansoor Ali
If
Shah.
we see in that dissent, there is a reference to a judgment saying that this cannot be done.
My lord, yes.
So 184(3) cannot look at matters.
True, my
if
lord.
review has been decided.
What I am pointing out to your lordship is that your lordship's dissent apart, there was a review petition. There was no 184.3 before this honorable court. The court dismissed the review petition. The court then opened the window under 184.3. Your lordship said it can't be done. Your lordship provided the same relief under review jurisdiction. Your lordship accepted the review petition, allowed it, granted the relief. So in terms of relief, it was the result was the same. Your lordship said the proper way of doing it is, we have a review before us. Let's decide the review. Let's say we made an error. The majority of the bench said, no, we dismiss the review, but we give them relief under 184.3. All that I am pointing out to your lordships is that your lordships have, in order to do complete justice under 187.
If we applied that test to the instant case, the review could have been dismissed by this court by saying that there's no error floating on the record or this point was not raised. But then the same relief could have been given under 184 or 187 if we applied that test.
But in the dissent, there's a reference to a larger judgment which was not considered by the majority. It's a settled law that you can't, under 184, go into review matter.
Relief we can deliver in this case.
My lord,
Indication.
in a presidential reference, your lordship is only answering a question. The question is, was this conviction and sentence in consonance with Article 4 of the Constitution? And if your lordship says yes, that's the end of the matter. Quite often.
That's a lot of things in it, you see. One is to go into the merits to examine this, which is perhaps not permissible. The other is to just look at the process from outside and see whether at all that was done rightly. So,
My lord,
just
I have
a question on the 2G judgment. What were the grounds for them to open this up?
My lord,
Was there any bias alleged?
No. On merits, the Federation found that the law had been incorrectly
So on
interpreted.
143, they went into the merits of the case.
Then to the merits, they said a president could ask the question if it could arise in future cases, and therefore this question was being asked.
And in this case, the review was decided already by the Supreme Court or no?
My lord, not that I am aware of.
But this is just a main petition.
Petition, and it's a presidential reference comes in, and the presidential reference is decided.
What the president is achieving from this reference, what he wants to.
My lord, the vindication of the principle of and the public interest in the fair administration of justice. A vindication.
But in this case, the level of difficulty was just they could have filed a review.
My lord, in the case before your, in this case,
Very impressed with the Indian judgment.
my lord, they have been doing it since 1951. So that was the earlier case where they again.
Are you saying that they've been doing it before my lord was born? Gives it greater gravity?
Sir, in Indian history, that's a tested and tried jurisdiction. My lord, let me put it this way. The court, when persuaded that justice was not seen to be done, will not stand by forms and formalities, then the court will hold that in this particular case a remedy could be provided. That's why your lordships have done under, my lord, otherwise under 184.3 jurisdiction.
Are you going to quote any other precedents?
My lord, two I have cited. There is a third one where an appeal came to this honorable court under 185. And in that appeal, the petitioner who had come to appeal on other grounds, the case was reopened under 184.3 and he was disqualified for life. Your lordships have now overruled that judgment, but virtually 184.3 was exercised.
Which one was that?
My lord, that's the case of Shaukat Aziz Bhatti versus Iftikhar Mahmood Khan, PLD 2018 Supreme Court 578.
This is overruled?
No, we've overruled
it in the Samiullah Baloch case.
We've overruled its effect.
Yes.
But you are saying the principle we haven't overruled.
No, the principle that under 184.3 that window was open to exercise that authority.
Where precisely in this judgment it was done?
My Lord, at page 589, paragraph 19.
Can we have the citation again, PLD 2018?
Yes, my Lord. My Lord, it is, the judgment is PLD 2018, Supreme Court, 578.
Matter decided and then reopened in 184.3.
This was a matter which came to the Supreme Court under 185. The Peshawar High Court had decided the matter. The respondent before your Lordship was not in 184.3.
Right.
The petitioner was not in 184.3. This was reopened against the respondent in 184.3 and the respondent was disqualified for life.
ये बताएं कि you've traveled to the UK and India, you want to travel anywhere else, so that's it.
My Lord, in US, to give your Lordship example, that case law is already in the bundle previously given to your Lordship.
Parliament can undo the judgment of the Supreme Court, any judgment of the Supreme Court.
My Lord, that would depend if the judgment was if the judgment was on a legislative issue. Parliament does that. Normally, your Lordship sees that in income tax ordinances cases, where the judgment, al-Samrez, molasses, many of these judgments have been overruled. Where the Parliament, where the issue involves an interpretation of the Constitution, Parliament may then amend the Constitution. Parliament may at times can now provide another interpretation. That issue is not before your Lordship. Your Lordship has left that question open, but in the recent judgment, the reasons for which came out yesterday, Parliament has made an attempt, even by sub-constitutional legislation, to have an impact on what the judicial interpretation of 62(1)(f) was.
But we didn't touch that.
Your Lordship didn't touch the legislation, but I'm showing it, my Lord, only as an attempt by the Parliament to do something. My Lord, in the United States...
Can we give any opinion to the President to take this matter to the Parliament?
My Lord, about...
To give opinion to the President to take this matter in the Parliament.
What will the Parliament do, my Lord, in this case? The Parliament cannot say that...
This is the question what we can do.
No. Your Lordships can say that this case, the process by which the finality of the judgment was reached does not square up with Article 4 of the Constitution, and the due process of law was not followed. That's the first question, and that's a question which can be squarely addressed by this Honorable Court.
So, Mr. Makhdoom, I'm all for correcting injustice. That's what we're in the business of, and correcting unjust history, whatever. But the question is, and you've also pointed out
that in common law, the threshold changes with time.
Right.
Your Lordship have seen in Pinochet in 2000, the threshold which existed in the entire common law history of the United Kingdom underwent a change. In the facts of this case, the threshold...
No, not in this case. I'm just generally saying that if we were to, there's a question that comes in from a president to look at a judgment. So some principles need to be there. We're not looking at the merits of the case. We're not looking at the principles settled. How do we approach this? We're looking at as you said, process. What do we really mean by that?
My Lord, that how was the result achieved? Your Lordship had looked at the process in one case, and that has been done in appeal, so that is why I cite it with a bit of trepidation. In the case of Asif Ali Zardari versus the state, this Honorable Court have looked at the process. Your Lordship, see, in substance, the judgment was not overturned in the sense it was set aside and remanded back. So the charges were not quashed. But the very fact that, in the words of this Honorable Court, a bench of the High Court was chasing the case, this created a reasonable...
Can you give the citation?
My Lord, I'll just give your Lordship the citation. My Lord, this is number 1. PLD 2001, Supreme Court 568.
This was the Kotekna SGS matter tried by the
जिसमें conviction हुई थी, 3 judges of the High Court in a 3-member bench convicted them. These were cases originating from the Ehtisab jurisdiction. Late Mr. Justice Rashid Aziz, late Mr. Justice Malik Muhammad Qayyum, and the bench refers to Justice Najmul Hasan Kazmi as well, who was involved in certain stages of the process. That's there in the Asif Ali Zardari case. And
it came up in appeal.
It came up in, that's why I'm saying.
Appellate jurisdiction was being exercised.
इसलिए मैंने कहा कि I cited with a bit of trepidation
I don't see the
because it's
relevance.
an appellate. All, my lord, for the principle. The principle laid down by your lordships was that where the justices were seen as chasing a particular case.
Where exactly, which page?
My lord, if your lordship takes a look at this case.
Can you just tell us the page number?
F1.
Your lordship will see page 589 of
F1 में
F1 में है सर, page 589 पे in particular है. उससे पहले 3 pages की discussion है which will take up lot of your lordship's time.
No, I just want to know the reference.
The findings start at page 587 and the principle laid down again is reasonable apprehension of bias, referring to the fact.
So the narrow window is bias, and this bias must be discovered much later. It cannot be contemporaneous. I mean, if it's there at that time, then this would not happen.
In this particular case,
Must be disclosed later.
In this particular
Bias is at that time, but the discovery is later.
The lordship will recall, before the hearing of the appeal, just before the hearing of the appeal, the Sunday Times published a report pointing out certain conversations. One need not go into it, but this is one of those cases as a result of which the learned judges of the High Court, though no finding of express bias or bias beyond reasonable doubt was established against them, they ended up resigning. One was a judge of the Supreme Court by the time this case was
I'm trying
decided.
to structure this narrow window by saying that bias was one, and the discovery of the bias takes is after the judge.
And what your lordship will see in the materials placed before your lordship, and I will, because the materials have now become multi-volume materials, I'll be submitting a written note identifying where exactly things are. Interviews of a judge who was a sitting judge of the Supreme Court at that time. Interviews of...
Who was that?
My lord, Mr. Justice Naseem Hasan Shah.
Okay, I thought you were still talking about that case.
Interviews of colleague judges and a judge who was the Chief Justice of the Lahore High Court initially.
We don't know when you cross Atlantic and when you don't cross.
Well, Mr. Justice,
back here.
Mr. Justice Aslam Riaz Hussain at that time.
Right.
Interview of Mr. Justice Durab Patel where he mentions some of these facts.
Okay.
A book authored by Mr. Justice Naseem Hasan Shah where he points out that the Attorney General and the judge presiding over the trial in the High Court who had delivered a guilty verdict met him in order to arrange more or less fixing of a bench. The book identified by my Lord Mr. Justice Mandu Khail, which showed that a meeting of corps commanders was called and senior officers was called to ensure that a particular outcome was secured. A book by General Faiz Ali Chishti who points out that how this verdict was secured. So there is, all those materials are on the record of this case which show that this was a case where a reasonable apprehension of bias in the judges who were hearing the case. The disquiet of the judges themselves, that the Chief Justice of the day sending one of the judges as an emissary to the 3-member bench to see that if unanimity could be achieved by reducing the sentence from death to life. And
so one more question, that even if we collect this material and say that there's a bias, is there any other natural justice principle that the person we're alleging this bias or attributing this bias to has to be heard?
No, my lord, that is the principle, because the principle is not that the bias is to be proved beyond reasonable doubt. The reason is that if that is where your lordships lay down the threshold to be, no case alleging bias will ever come to fruition. Your lordships are not protecting a member of the judiciary or running down a member of the judiciary by holding bias.
No, but that will happen.
No, but what your lordship will see.
Suppose if you attribute bias, then you are tarnishing somebody's reputation?
My Lord, that is why in Pinochet, every single judge said, we are not alleging bias against Lord Hoffman. Yet he is disqualified on the ground of bias, and yet this judgment is unsafe on account of bias. So that is where the reason is, my Lord, that is why over the years the common law has evolved the test which was called the real danger test in Crown.
I don't know why they, this hypothetical observation, but it could have been easily said rather than bias that it may be perceived by the general public that the judge is deciding his own cause. It not necessarily bias, and this perception that justice must not only be done but be seen to be done, as opposed to bias, means that I think it's a state of mind. And here really what they were alleging was, you are a beneficiary, or your wife is, of an organization, that organization was before your lordship, you should have recused yourself, not heard it. So whether there was or was not bias, I don't know why are we using the word bias here.
My Lord, because the use of the word bias...
Unless that's the word available.
My Lord, that's the word, your Lordship has hit the nail on the head, because that's the word available in common law jurisprudence.
There is no other word.
They were in bias had two categories.
Or he was under pressure.
Sorry?
Was he under pressure? This cannot...
My Lord, in this particular case, Pinochet is on a much lower level.
Yes.
There is no allegation of him being under any kind of pressure.
He himself admitted that आप पता है हम तो बहुत कमजोर लोग हैं.
Sir, वो तो केस फिर higher plane पे हो गया ना. That is an even easier case to disagree with. In Pinochet, they all say he was not biased. And your Lordship pointed out to the wife, my Lord, virtually when your Lordship reads through the law report, your Lordship will see the allegations vis-a-vis the wife were virtually dropped. They were not pursued. The allegation pursued was that he was a member and director and chairman of a charity which was controlled.
Your own type case.
And they said...
Don't be a judge in your own cause.
And why they were, my Lord, looking at it? Because they needed to broaden the category. Till that time, in common law, automatic bias, automatic disqualification only happened when there was a financial or proprietary interest, a pecuniary or proprietary
You're saying that as far as this narrow window is concerned, a perception of bias will do the trick?
My Lord, yes. A reasonable suspicion of bias.
Suspicion of bias.
A reasonable suspicion of bias.
So if while hearing this reference, can we exercise our power under Article 187?
No.
Whether any separate petition is required, or we can do in this petition, or even one of the petition, can we convert it into a petition and decide it?
My Lord, when hearing a matter, your Lordships have already held in the Hisba Bill case that whatever your Lordships decide in the reference jurisdiction is binding on all the courts in the country. So for all practical purposes, you lay down a binding judgment. And because your Lordships have said that, your Lordships, when deciding 186, 187 is an enabling provision. It allows your Lordship to do complete justice. It does not create a new jurisdiction. When exercising your authority in 186, your Lordship will not say that we will look away what would be complete justice or substantial justice in this case. 187 can be brought into service over here under a 186 jurisprudence. Your Lordship, my Lord the Chief Justice, your Lordship is absolutely right. They didn't have to. The only reason why they did was that automatic bias before this judgment, automatic disqualification before this judgment took place only in the cases of pecuniary or proprietary interest. They said automatic disqualification will also take place where there was some other interest. So that is the test. That if there is another interest...
So according to you, I mean, the outcome of these proceedings, according to you, would be that having considered all this material, we think that this decision had reasonable suspicion of bias, we think, and hence it is what?
My Lord, hence it did not square up with Article 4 of the Constitution and the requirements of the due process of law, which is the first question. If your Lordships answer that question and do not want to go into the greater controversy of whether the case was itself in substance correctly decided or not, then that is sufficient. Your Lordship...
I think these are. Do you have any other case to cite?
My Lord, only which two cases which I had pointed out earlier, I will refer your Lordship to them. My Lord, Mr. Justice Mansoor Ali Shah was keenly interested in what is happening in other jurisdictions. My Lord, some materials came to my hand last night. I'll be submitting those later in photocopied form. But if your Lordship sees this volume number 1, Volume 1, your Lordship will see after the article by Lord Bingham at item number 16, there are 3 books, 17, 18 and 19. One is on miscarriage of justice, the other is on the Criminal Cases Review Commission, and the third is wrongful conviction international perspective. So what is happening in the world over to correct miscarriages of justice? And what is happening is that in England too, they have now created, even if the judgment has attained finality, what they call the Criminal Review Commission, Criminal Law Review Commission, where a reference can be made to it. And that is how, my Lord, the convictions of the Birmingham 4 were reopened. Many of these, again, as my Lord the Chief Justice mentioned, sometimes the circumstances are so compelling.
They were reopened in appeal, or?
My Lord, under this new jurisdiction created through the Criminal Law Review Commission, the Home Secretary made a reference and the Court of Appeal then overturned the earlier convictions. In US, my Lord, in Canada, they have done the same. Your Lordship will find it in these materials. They have done the same in Northern Ireland. They have done the same in a number of jurisdictions. In US,
but they've done it through some statutory...
They have. In US, they do it through the common law jurisdiction. In US, they have...
In US, there's no statute.
No statute. What they have done is kept alive the Old English jurisprudence, which is now no longer used in England, which was called the writ of coram nobis, which meant the writ to correct errors.
How do you spell that?
C-O-R-A-M N-O-B-I-S.
N-O?
N-O-B-I-S.
That is, I think,
for Pakistan.
Curative jurisdiction.
B for my Lord Bombay.
Curative.
My Lord, coram nobis to say, yes, if an error has been made, we can cure it. Now, of course, the issue before your Lordship would be that sitting on your own, under 187 you can't reopen the case, but if a case comes to you in the 184.3 or comes under 185 or comes under 186, your Lordship...
But we cannot exercise curative jurisdiction under Article 186.
My Lord,
it is
your
only
Lordship...
a matter which in Supreme Court reports the opinion.
It's not a curative jurisdiction.
Yes.
It's an authority with the court to recognize that it has committed an error.
For instance, can we, for instance, now take a very, a practical thing. The judgment under review states that the approvers, primarily approvers' evidence was the determining factor. Now, can we, giving in an opinion, say capital punishment or this is insufficient in a murder case to totally rely upon an approver's testimony? I mean, that will be settling a principle of high courts and other courts.
My Lord, that's one way, but that goes to substance. Your Lordship may do the same thing in process. I'll give you an example of process. Mia Abbas and the 2 other witnesses were not inclined to give evidence in a particular way, and that has come through contemporaneous materials. That is there On the YouTube, Your Lordship will find it. I have will be placing that disc before Your Lordship. A junior of Mr. M. Anwar on the YouTube saying that how he saw what happened between judges and a former chairperson of the Amir Jamaat Islami in that case, and how these convictions were procured, the evidence was procured. Your Lordship will find that in a letter of Mr. Sharifuddin Pirzada, which forms part of Mr. Rafi Raza's book, which I read out last time, where he says that General Iqbal brought it to his attention that the approvers were saying that their testimony was not independent. They were compelled to give this testimony. And he giving an opinion then that in that case the conviction cannot stand. On that opinion, he then pointing out that virtually in so many words that Maulvi Mushtaq Hussain approached General Ziaul Haq, and the Supreme Court then issued us, and Justice Ghulam Safdar Shah made a statement saying this is what has happened. The Supreme Court was then prevailed upon by General Ziaul Haq to issue a statement correcting what Mr. Justice Ghulam Safdar Shah had stated. Now this shows to you that the process was not based on simply what evidence was there, but was vitiated.
So basically you're saying that, I mean, there could be bad judgments and there are wrongly decided judgments of this court. That's not our business. We're not touching those. We are only limited to a judgment where the process is so seriously biased, which is outside the merits of the case. It is the process, it's the way judges were performing. Could we touch those in this jurisdiction? We can't go into the merits of the case, neither can we say it was a bad judgment, it settled wrong law. That's not our problem. It is only the process, and it only relates to the judge.
My Lord, where else would you find a case where one of the dissenting judges, Mr. Justice Ghulam Safdar Shah, publicly speaks and says that this approver evidence was, my word, not his, procured? That the Attorney General of the time writes a letter to Mr. Rafi Raza in which he says that he then communicated to Maulvi Mushtaq Hussain, who approached him, that this would result in the conviction being rendered unsafe and being reopened. Maulvi Mushtaq Sahab then, it appears, he doesn't say though it explicitly, apparently spoke to General Ziaul Haq, who sent out the then Attorney General for treatment, and the Supreme Court issued a press statement. You will not find another case, my Lord, where another judge who was in the majority says that the judge, the Chief Justice of the High Court, visited him with Mr. Sharifuddin Pirzada and wanted the composition of the bench to be of a particular kind. This squares up with Your Lordship's jurisprudence in Asif Ali Zardari of a bench chasing a case. He had decided the case. He had no business to fix the benches in the Supreme Court. Naseem Hasan Shah Sahab saying, it's not proper for me to sit, I am an ad hoc judge, but if my Chief Justice so directs...
we noted that.
Yes. And
I remember reading, I don't know, it's about the cat.
About?
The cat. Was it said by some judge or not?
About the cat being out of the bag?
No. That I won't hang a cat or something like that.
It is, my Lord,
who said
it
that?
is attributed to Justice Qaisar Khan. That remark is attributed to Justice Qaisar Khan, who said during the course, my Lord, probably in contemporaneous newspaper reports it came out somewhere.
And he was not...
I will take a look at the contemporaneous newspaper reports as well, if I can, that you cannot hang a cat on this evidence. Or something to that effect.
So you've heard it?
Yes, my Lord. It was widely quoted.
I had heard it, but I don't remember where it was or who said it.
So it was attributed to Qaisar Khan Sahab. And then, my Lord, where else would you find that Justice Dorab Patel saying that he wanted Justice Wahiduddin Ahmad to remain on the bench, and Justice Naseem Hasan Shah Sahab also saying that Qaisar Khan's tenure could have been, if he had been given an extension, the composition of the bench would have remained the same, and inviting them to participate in the judgment. And then Mr. Justice Naseem Hasan Shah writing in his book that had the composition remained the same, the majority was with Mr. Bhutto. That's no interview, that's his book. So it would have been 5-4 in favor of Mr. Bhutto's acquittal. Durab Patel sahab also saying in the interview which your lordship will summon from the archives, your lordship will see.
PTV का जो आपने जिक्र किया दुराब पटेल का, is that before us or not?
Sir, it's not before you. The clips are in YouTube. I have got a clip.
No, Mr. Raza Rabbani has not filed
My
it.
lord, if he has, I think Mr.
I don't know if anyone has filed it or not. Sorry, Mr. Farooq Naik. He's referring to some interview
my
by
lord.
Durab Patel.
I have filed clips.
Of this PTV. Okay.
पूरा interview PTV archives में.
We can get the whole interview and file the clips of Mr. Justice Durab
नहीं,
Patel.
if you have, if you think
Yeah,
that's
we already
sufficient.
filed it. We have already filed it. When my turn will come,
ठीक है,
we will get
Mr.
it.
Naik, like me, has the clips.
Yeah.
If your lordship wants to see the entire interview, that's in PTV archives.
ठीक है. Okay, we'll bear that in mind.
Your lordship will have to summon that.
जी, please, continue quickly.
The submission is that
I just want to push you a bit.
Yes, my lord, I
hope you don't mind.
Not at all, my lord. My lord, Mr. Justice Yahya Afridi asked that question. What other materials, my lord? The two other materials which I would request your lordship to look at are the two judgments from the US jurisdiction, the federal court judgments which I have referred to several times. These are at serial number 13 and 14 of this blue bundle index volume 1. And in both cases, the federal court overturned in a way. Pages 79 to 84 is one, and 85 to 102
79?
79, the handwritten page 79, my lord.
Okay.
What jurisdiction was used?
US.
My lord.
No, I mean...
Supreme Court.
Federal court.
No,
my lord,
Supreme Court.
My lord, in the Supreme Court, the matter went during the wartime, and the appeals of both Hirabashi and Korematsu were turned down by the Supreme Court. After the war hysteria was behind them, they went to the court and they said that what had happened to them.
So they were decided matters during the wartime.
A lower court undid it.
The lower court undid. They exercised the jurisdiction of writ of quorum nobis.
No, the matter didn't go to the Supreme Court.
No, because the state never appealed. The state didn't appeal, my lord, because what was asked.
So I think both the extreme position हो जाएगी.
But sir, why the state didn't appeal is that the president of the day had apologized to the Japanese citizens who had been interned during the war.
We understand that, but a lower court undoing a Supreme Court judge.
Yes, they are saying.
And the other one is?
The other one is, my lord, 85 to 102. That 85. Again is lower court undoing that and granting relief, and granting compensation. The overruling by the Supreme Court came much later. The overruling by the Supreme Court has come virtually very, very recently. I'll just give your lordship the year. In the case of Trump versus Hawaii, this is 2017 judgment where the overruling has come in, and the relevant page is page 38.
This same booklet.
Yes, my lord, this is volume 3 and this is tab 11. The citation is
ये आप कौन सी वाली में?
जो आज दिए सर.
अच्छा आज दिए. Which one? Page?
Tab 11, the last page of this. I have just filed an excerpt because it's a very long judgment.
What had happened?
The Supreme Court now says the dissent's reference to Korematsu, and the Korematsu citation is there. It was decided in 1944. The dissent's reference to Korematsu, however, affords this case the opportunity to make express what is already obvious. Korematsu was gravely wrong the day it was decided, has been overruled in the court of history, and to be clear, has no place in law under the Constitution.
Is this the same Trump, the President Trump?
Gee, this is the President Trump's
case. What was this case about?
My lord, this case was about Mr. Trump making, I think this is insofar as I recall the facts.
Just very briefly.
There was a proclamation issued by the President, and that proclamation had come up before the Supreme Court.
Okay.
The Homeland Security's proclamation, this related to some of the countries and immigration restrictions. My lord, another important judgment which your lordship may like to take a look at is the last case. It originates from Singapore, and
Tab 13.
Tab 13. May I say so? This is Mr. Justice Sundaresh Menon, who is now the Chief Justice of the Court of Appeal, which is their Supreme Court. He is, however, deciding this singly, so his title is a Judicial Commissioner. And may I just read out, my Lord, your Lordship will see the opening paragraph that is there. That settles the principle, and I'll sit down after reading it.
We've glanced through it, huh?
Yes, my Lord. If your Lordship may see paragraph 12 only. Last two lines. The issue in an application for judicial review is not whether the tribunal, the findings of which are the subject of the challenge, has reached a decision that the courts considers is correct. Rather, it is whether it has proceeded correctly, observing the applicable due process requirements. I am on the second link. And that's all, my Lord.
Anything from Islamic jurisprudence?
My Lord, on the issue of a person, I've been submitting materials that a person who is interested in the outcome of the case is unfit to be a Qazi and should not be presiding over the case. That is settled law. A fair hearing is settled law in Islamic jurisprudence. I will place the books on record.
Thank you.
Thank you, sir.
For your help. And I must say that you've done a lot of homework on this.
Thank you, sir.
So now if we can just do a little homekeeping and decide how we're going to proceed on the next date of hearing, because I think it's now 3 o'clock.
So
May I, my Lord, before the Lordship do that, offer a personal apology to Mr. Justice Hilali. In photocopying the bundles which were done today overnight, the photocopier made a mistake and photocopied one bundle less. I apologize. That bundle will be placed before Her Ladyship today, but my unconditional apology for that.
I'll provide mine to her. Gender balance comes first.
Who are the other micas? Salahuddin Sahab. Salahuddin Sahab, how long will you take?
About 45 minutes to an hour.
Okay. I hope you're traversing ground not already covered. Yes. And I'm sure you must have, there must be commonality. So if you can just now excise that portion, because unless you are not supporting him altogether, that will be different. But otherwise, if you can break fresh ground, we'll appreciate. Are you filing anything for us to see, or have you filed already?
I haven't filed yet, sir. I will be filing.
आप करें ना आप काफी हमने वक्त दिया था अच्छा और कौन है माइकस इसमें आज आपका स्टेज 2 में आ रहे हैं
जावेद खान साहब हैं
खालिद जावेद खान
हाँ he's not well okay आई हैं अच्छा उनकी रिटन सबमिशंस आई हुई हैं ठीक है तो मेरे ख्याल में हम आप भी तैयार हो जाएं क्रिमिनल के लिए बिकॉज वी वोंट डिवाइड इट इनटू 2 एंड वी वुड रिक्वेस्ट आपने कोई चीज फाइल की राइटिंग में कर दिए ओके एंड मंजूर मलिक साहब ने कुछ फाइल किया है रिटायर्ड जस्टिस मंजूर मलिक साहब हाँ जस्टिस रिटायर्ड मंजूर मलिक साहब ने कुछ किया अच्छा तो वो अगर आना चाहें तो वो आ जाएं या वो फाइल करना चाहें फाइल कर लें जैसे भी करें ठीक है तो क्या करें
documents which have been given to the court on the complainant I must be given relevant documents so that I can answer when my turn comes.
We will ensure that Mr. Makhdoom Ali Khan is further spends money.
My Lord, it will
Can you please provide a set to Mr. Kasuri as well?
The complete set which has been given to this honorable court.
I think aapka bhi kaam aasan hoga. He's very diligently put together all the case law. He's a amicus in the case. So and these cases that he cited, many of them are not available in book form here. So can you do
all the volumes will be given to him. It will photocopied and given to him.
अच्छा तो अब आप ना राब्ता डायरेक्ट कर लीजिएगा मखदूम साहब से अगर उन्हें 2 दिन में नहीं दिया आप उनको फोन करके कह दीजिएगा he will honor it rest assured अच्छा तो आप लेंगे about half an hour 45 minutes अच्छा how long will अच्छा खालिद जावेद खान साहब ने फाइल कर दिया कुछ एंड आप कितना लेंगे या आप कुछ नहीं कहना चाहते हैं राइटिंग में दे दिया आपने अच्छा ओके दैट्स गुड रज़ा रामानी साहब आप कितना लेंगे वक्त
about at least 2.5 hours
Because if you, the only thing is, we would love to hear this endlessly, but please be aware that my Lord has very few days left, so at least if the hearing is concluded, the judgments can come later also. But and we are so if you can supplement your things in writing if you want to do that.
My Lord, I've already done that. I haven't submitted it, but I have my synopsis ready. And out of that, I'll only be picking up 2 to 3 questions which your Lordship had put in the order of the 12th. And I will take those up. The others I will...
Otherwise, what will happen is reconstitution of the bench, and you know that.
I know.
Means the case will probably never get heard.
I'll try and be as short as...
So, no, we don't want to push you, but you are aware of this.
I'm aware of it.
जी, ठीक है. Zahid साहब, आप कितना लेंगे?
Sir, I'll take...
Half an hour.
I'll take, I represent Mr. Bilawal Bhutto Zardari. I'll take about 1 hour, my Lord, at least 1 hour.
Somebody was
नहीं, मगर ये चीजें just bear in mind.
जी, मैं repeat नहीं करूँगा, sir. I will not repeat.
No. We want to cut short, but then reconstitution means, if it ever happens even.
तो आप मैं समझता हूँ
बड़ी मुश्किल से हमने यहाँ तक लाया इसको.
जी, एमाइकस के बाद अगर आप हमें दे दें, क्या कहते हैं, तो
नहीं देखें, एमाइकस का फायदा होगा. एमाइकस के बाद तो नेचुरली आप ही आएंगे ना फौरन.
एमाइकस के बाद
कंप्लेन उसके बाद कसूरी साहब आप खुद बहस करेंगे या आपने कोई वकील किया है? Because just one word. No, it's enough.
I'll be talking about the actual case because I have seen.
ठीक. नहीं, हम सिर्फ पूछ रहे हैं कि अगर आप वकील करना चाहें, आप कर सकते हैं.
No, from the folks are from the
सर मेरी इल्तिजा होगी एमाइकस के बाद आप मुझे इजाजत दे दें, फिर रजा रब्बानी साहब को दे दें.
He will have the last word.
जी नहीं, रजा रब्बानी साहब को दे दें और फिर क्या कहते हैं.
Yeah, that's how you proceed.
Zahid साहब.
Yeah, we'll finish everything because amicus are supposed to be neutral. Naturally, you and Kasuri Saab, because it's your case, so he has the right to say that I have the last word after he hears what you say.
After क्या कहते हैं अपने सलाउद्दीन साहब के बाद मुझे चांस दे दीजिए, फिर
जब आप डेट पे एग्री कर लें.
जी सर, डेट आप जो हुक्म करें
नेक्स्ट वीक में.
जी हाँ, जो हुक्म करें.
मंडे को रख लें.
मंडे को रख लीजिए.
Do you need to come? If you are available, please do. Some queries come up.
Tuesday को रख लें तो that would be better because we all come from Karachi. Tuesday would be better, sir.
तो किसी को तो मंडे को.
Javed Khan has sent a request for 28th, but that's up to your Lordship.
मंडे को हम करते हैं. मंडे को आए ना, अब संडे को आ जाए कराची से.
ठीक है सर, मंडे को कर लीजिए. ठीक है. We'll be here, sir. We will be here on Sunday.
Otherwise, we'll report you to whoever we have to report you to.
वही तो कहती है कि संडे को भी तुम चले जाती हो.
So bring her along. Good weather in Islamabad.
आपका मुकम्मल इख्तियार नहीं है.
बिल्कुल सर, किसका है? किसी का भी नहीं है.
मैं आपको पूछना चाहता हूँ.
जी अच्छा.
Mr. Khalid Javed Khan will be coming, or he just submitted something in writing?
My Lord, he told me that...
Does he want to be heard, or he just said, I filed whatever?
My Lord, he said that if this case is fixed on the 22nd or the 28th, he would be here and also make...
Monday hai?
28th is Wednesday.
Hey, वो पता नहीं हम फिर कैसे चलेंगे. If someone is not available, we can maybe hear them and then they can come.
Monday,
ठीक है? But चलें तो फिर Monday को हम करते हैं 11:30.
Thank you, my Lord.
Monday को, हाँ पता है. नहीं मंडे को तो कोई नहीं बेंच. कोई बेंच ट्यूसडे को कोई बेंच है. ठीक है. We try to do as unless there are other benches, so we want to finish it as soon as early. By all means, you can give submissions in writing later.
Yes, my Lord.
तो लिखें.
This week, my Lord, I have a personal difficulty.
No, we don't. We're not doing it this week.
But next week, I
Monday को कर रहे हैं ना. because you've concluded.
Yes,
So
my lord.
now if you come on
in terms of written submissions as well, my lord, because I have to rush back to Karachi.
no rush on that.
Thank you very much.
Because it's too much material for us to absorb. You can take your time about that. No rush at all.
Thank you, sir.
The most thankless task is of a amicus.
No, it's always an honor, my lord.
इसमें लिखिए Mr. Makhdoom Ali Khan, learned amicus, Mr. Makhdoom Ali Khan has made his submissions and states that he will be filing written amicus brief.
My lord.
Full stop. Mr. Salahuddin Ahmed, learned Mr. Salahuddin Ahmed, who is another amicus, states that he will take about 45 minutes. Mr. Khalid Javed Khan has submitted written amicus brief. In case he wants to make submissions, he may do so on the next date of hearing. Thereafter, आपने भी कर दिया है ना? आप कुछ आर्ग्यू करेंगे या सिर्फ फाइल करना है?
It's written with the
Filed states that he's filed thing, and unless called upon to do so, he does not need to add anything further. Justice retired Manzoor Malik may file or make submissions after the full stop. Learned counsel for the children oblique grandchildren of the late Mr. Zulfikar Ali Bhutto will then be heard, and lastly Mr. Ahmed Raza Kasuri, the complainant in the case, if he wants to engage a counsel, he may do so. Full stop. To come up on Monday ki tarikh, Monday, 26th February 2024 at 11:30 p.m. All the learned amicus and counsel and parties are requested to be as precise and brief in their submissions. However, any one of them may file further written submissions.
My lord, the person who is the cause of all this trouble, the learned Attorney General, is not mentioned in this betting.
Oh,
he's the mover and shaker of the reference.
He's been hiding, no wonder. The cause of the trouble, how long will you take?
No, my lord, I might not take too long. I might
a former Attorney General is calling you a troublesome Attorney General.
But I have inherited this, so I may be excused.
You're following in his footsteps, I think.
So I might not take much time because a lot will already have been said by that time. So I think I'll try to just keep it to half an hour and not more, sir.
Maybe you go at the very last.
That is how.
After Mr. Kasuri.
Of course, man.
Because we expect the greatest neutrality from the Attorney General on matters of law under Article 100 of the Constitution.
That's how I.
So Kasuri साहब को कोई इतराज ना हो, तो he will go last. You will go second last. ठीक है? ठीक है. उसमें Attorney General का भी तस्करा कर दें last. Thank you, gentlemen.
Thank you, sir.
And ladies.